I will pardon my lord. An order dated 1807 has been wrongly
You mentioned tomorrow.
I am conscious of this. I am conscious this honorable bench have not passed that order.
Tomorrow.
My lord, I am filing written note submission of WPC 5049 of 2008 on behalf of Mr. P.K. Naik.
Justice Mr. Hon'Ble, what we do. He received level data.
May I please also permission to make a mention for a memo? This is
And you mentioned tomorrow. Hello? Yes.
Supplemental list, item number 1.
Please, your lordship. In item 1, we are filing written notes today.
By statement written note by Mr. Panna.
Written notes along with judgment.
Appellant number 5. Written note. Appellant number 5.
Yeah,
Mr. D. Naik. Appellant number 5. Number 5. As a relevant date chart or written note. ये तब तक और अरे दिया मुझे रखी नहीं बना. This is date.
That was everything. We did not sufficiently.
Since both the appeals were there, we have mentioned it thereafter.
Also, CRLA number.
Dita Jakore Amar.
Okay. That means it is filed on behalf of Mr. D. Naik.
Yes, sir.
Along with the citation.
Yes, sir.
What about Mr. Dhar?
Lordship, we had already filed on that day.
Bhada had earlier filed the.
On that. Actually, written note.
Lordship, we have already filed the memo.
Okay. Actually, Mr. Dharanidhar Naik, and senior advocate, appearing for the some appellants in some of the appellants in criminal appeal number 193 of 1997, as well as criminal appeal number 47 of 1998, has filed the written note of submission along with some citations which have taken on record. Land counsel for Mr. Devasis Panda, Land counsel, appearing for the appellant number 5, has filed a date chart. Also the written note of submission which have taken
And memo of citations.
and a memo of citations.
Yeah, that's the last memo of citations. At the last page of the note, my lords, the
Written note.
citations. Aye.
list of citations which are taken on the test. When counsel for the state has filed the written note of submission, which is taken on record
Citations are there.
along with citations. Hearing is closed and judgment is resolved. Yes.
Much obliged.
Obliged.
You
services.
ठीक है from the next meeting.
Item 2.
In item 2, my lords, I am also appearing. But
Yes.
my difficulty is that I was ill, my lords, from Friday onwards. So may I pray it may be taken up next week. I am not in a position to make sustained arguments. Although note and everything is ready. In
Oh,
fact, it was
oh.
heard by a bench.
Why, Junior Panda, let him start to you will
My lords, it is better that I finish and I start and conclude. On Thursday, otherwise, your lordship may keep it. I'll be done. It was argued, in fact, before another bench, so everything is ready. I can only I can place the whole thing at one go.
about the next item.
Item 3.
Anybody is ready, Mr. Naik, have you contacted? Anybody from the list?
Mr. Panda, you have also got another item in item number 6 also.
I concede, my lords. But I thought somebody will be, otherwise I'll begin item 2, my lords. Let's start.
I just one item at least we want, sir.
No, then I will begin item number 2, my lords.
What about Mr. Saktidhar Das? He was
The other
looking
day
to
you
argue
said-
some matter.
I make a mention that I need to paper book in pen drive, let's see.
Uh-huh.
I need paper book in
Paper
pen drive, let's see. Because I have that paper book with me. That let's see, some pages are not completely not visible. I have that paper book with
No, it's all right.
You start with.
Start with it. Let us see that.
You can.
You have, Wakam is there. Just there are 2 criminal appeals.
Let's see.
So give the paper book, let us see. From the impugned judgment, it appears that there are 4 appellants.
Let's see.
Sorry, 4 accused persons.
Correct.
And charge was filed under 302,
Let's see.
307, read with section 34, section 25 and 27 of the Arms Act.
Exactly.
So ultimately, what the London trial court did, whether he convicted all or
Let's see, he has convicted all the.
Acha. So now if 4 persons, then there are 2 appeals.
Let's see.
So is it a appeal of 2 or like that, or how many appellants is there in?
4 appellants in 2 appeals.
No, CRLA number 252.
Yeah, let's see.
How many
Appellant number 1, Satyajit Mahapatra.
The CRLA 252. Hey. CRLA 252 it was appeal memo. There are two appellants,
Let's see.
out of which one has abated
Let's see.
as per order dated 10/9/24.
Let's see.
So this remains only for
Satyajit Mahapatra.
So CRLA 25298 only survives for Satyajit Mahapatra. Then CRLA 290 of 1998. Appeal memo देखो. This is for two. Okay. Vijay Kumar Rao and A. Jagadish Rao. Now, all the appellants are on bail.
Let's see. And in the CRLA 290 of 98, that Jagadish Rao has, in each case, is abated.
Thank you, Chief. Adil Lekhaini acha. Who ordered to phone to them?
Yeah, order dated 10/9/24.
Okay. So, this also remains for one. Vijay Kumar, huh?
Let's see.
One paper with them.
So, Jogeshwar Suna and A. Jagadishwar Rao,
Let's see. Abated.
these two.
Google ID बोलो. So, DOS field के लिए answer. So, the Jogeshwar
Yes,
Sunnar, he has expired, abated as per order dated कितने? CRLA 252 टका 10 no?
10
Okay.
the combined order sheet is combined order sheet is CRA 252 and CRA 290 order is the Jankar, Jagdish Rao and Jogeshwar Suna. The Jankar is
किताब जमाने 10/2024
A CRA ରୁ ଗୋଟେ ମରିଛି ଆର CRA A ଜଗଦୀଶ
So,
ସେ ତାର ଗୋଟେ କମ୍ପିଟିସନ ରଖା ହେଇଛି
292 फिल्म 290 फिल्म बड़ा
December good.
इनका आरंभ है सत्यजित महापात्र और जोगेश्वर दीटा तीन 27 भीतर अच्छे
252 tax deal row. Base. That's it. Then the surface.
आज मैं उठी अच्छी 290 এটা আছে 15 পেজ আছে। ଇଣ୍ଡେକ୍ସ ରେ ଅଲଗା ଅଲଗା କରିବା କଥା ଆକ୍ଚୁଆଲି ଯେତେବେଳେ କରିଦେଇଛି ଗୋଟେ 291 ଯୋଉ disloded ହେଲା ନା Right. Rated. Of dated 10/9/24. Come to the first information report.
Page 78.
Page
78. 51.
କଣ
ମୋର ନାଁ MD ସୁରେଶ ପୁର୍ତି, ପିତା ଲାଲ ସିଂ।
ନା PW ହରିଆ କହିଦିଅ
Informant is the PW1 also.
MD ସୁରେଶ ପୁର୍ତି ହେଲା PW1
also. ପିତା ନାମ ଏମିତି ଜିଲ୍ଲା ଶୁଣିବି ବିହାର।
ରିସିଜ ନା କଣ
ବିଶେଷ ନାଁ ହଉଛି ଅମିୟ ଦାସ ନରସିଂହ।
ଆଚ୍ଛା ପଢନ୍ତୁ
କ୍ୱାର୍ଟର ନେବେ ସୁନ୍ଦରଗଡ଼। ଆଜି 29/10/96 ରିଖ ଅପରାହ୍ନ 2ଟା ବେଳେ ସୁନ୍ଦରଗଡ଼ ଜିଲ୍ଲା ହେଡକ୍ୱାର୍ଟର ହସ୍ପିଟାଲରେ ଡାକ୍ତର ମଇନା ହେଉଥିବା ବେଳେ ଟାଉନ ଥାନା ସବ ଇନ୍ସପେକ୍ଟର ବାବୁ ଆସି ମୋତେ ଘଟଣା ବିଷୟରେ ପଚାରିବାରେ ମୁଁ ତାଙ୍କ ସାମ୍ନାରେ ଏହି ମୌଖିକ ରିପୋର୍ଟ ଦେଉଅଛି କି ମୁଁ ଛେଣ୍ଡ କଲୋନୀ ରାଉରକେଲାର ଓକିଲ ଅମିୟ ଦାସଙ୍କ ଆମ୍ବାସଡର କାର ନମ୍ବର OR05
ଅମିୟ ଦାସ ଇଜ ଦି ଡିସିଜ୍
କାର ନମ୍ବର OR05 1867 ର ଡ୍ରାଇଭର ଅଟେ। ଗତ 27/10/96 ରିଖ ରବିବାର ଦିନ ସକାଳୁ ଅମିୟ ବାବୁ ଓ କଲିକତାର ଜଣେ ଓକିଲ ଆଢିଅ ବାବୁ ଲର୍ଡସିପ PW8
ଓକେ
ଆଢିଅ ବାବୁଙ୍କୁ ମୁଁ ଉକ୍ତ କାରରେ ରାଉରକେଲାରୁ ଆଣି ସୁନ୍ଦରଗଡ଼ ଦେବାଶିଷ ଲଜ୍ ପାଖରେ ପହଞ୍ଚାଇଲି।
So this PW1 is a driver or what?
Lordship,
Yes,
driver of the deceased vehicle.
No, driver of the vehicle belong to the deceased.
Belong to the deceased person. କଲିକତା ଆଢିଅ ବାବୁଙ୍କୁ ମୁଁ ଉକ୍ତ କାରରେ ରାଉରକେଲାରୁ ଆଣି ସୁନ୍ଦରଗଡ଼ ଦେବାଶିଷ ଲଜ୍ ପାଖରେ ପହଞ୍ଚାଇଲି। ସେମାନେ ଉକ୍ତ ଲଜ୍ର 32 ନମ୍ବର କୋଠରୀରେ ଦିନ ପ୍ରାୟ 11 ଘଣ୍ଟା ସମୟରେ ରହିଲେ। ସେମାନେ ଗୋଟିଏ ମର୍ଡର କେସ୍ ବାବଦ ନେଇ ସୁନ୍ଦରଗଡ଼ କୋର୍ଟକୁ ଆସିଥିବାର ମୁଁ ଜାଣିଥିଲି। ତା 28/10/96 ରିଖରେ ମୁଁ ସେମାନଙ୍କୁ କାରରେ ନେଇ ସୁନ୍ଦରଗଡ଼ କୋର୍ଟକୁ ଗଲି ଓ ଓ କୋର୍ଟ କାମ ପରେ ପୁଣି ଲଜକୁ ଫେରି ଆସିଲୁ। ଆଜି 29/10/96 ତାରିଖରେ ମୁଁ ସେମାନଙ୍କୁ ପୁଣି ଦିନ ପ୍ରାୟ 10ଟା ବେଳେ କୋର୍ଟରେ ଛାଡ଼ିଲି ଓ ପ୍ରାୟ 12ଟା ବେଳେ ସେମାନଙ୍କୁ ନେଇ ଲଜକୁ ଚାଲି ଆସିଲି। ଦିନ ପ୍ରାୟ 1ଟାଏ ପାଖାପାଖି ହେବ। ଅମିୟ ବାବୁ ଡିସିଷ୍ଟ ରାଉରକେଲା କେସ୍ ଫେରି ଯିବାକୁ କହିବାରୁ ମୁଁ ତାଙ୍କର କୋଠରୀରୁ ଆଟାଚି ପତ୍ର ଆଣି ଲଜ ଆଗରେ ଥିବା ଆମ କାରରେ ଜିନିଷପତ୍ର ରଖି ନିଜ ସିଟରେ ବସି ପଡ଼ିଲି। ପ୍ରଥମେ ଓକିଲ ଆଢିଅ ବାବୁ ଆସି କାର ପଛପଟ ସିଟର ବାମ ପଟେ ବସିଲେ ଓ ଏହାର 5-7 ମିନିଟ ପରେ ଅମିୟ ବାବୁ କାରର ବାମ ପାଖ ଦୁଆର ଆଡ଼କୁ ଆସିଲେ। ଆଢିଅ ବାବୁ ତାଙ୍କୁ ସିଟର ଡାହାଣ ପାଖରେ ବସିବାକୁ କହିବାରୁ ସେ କାର ପଛପଟ ଦେଇ ବୁଲି ଆସି ଠିକ୍ ଡାହାଣ ପାଖ ସିଟରେ ବସିଲା ବେଳକୁ କାରର ଖୋଲା ଥିବା ଡାହାଣ ପାଖ ଗେଟ୍ ମୁହଁ ଦେଇ କେହି ଜଣେ ଲୋକ ଅଚାନକ ଅମିୟ ବାବୁଙ୍କ ଡାହାଣ ପାଖ ଛାତିରେ ଗୋଟିଏ ପିସ୍ତଲ କି ରିଭଲଭର ଦ୍ୱାରା ଗୁଳି ଚଳାଇ ଦେଲା ଓ କହିଲା କି ତୁ ମୋର ବାପା ଅନନ୍ତ ରାଉତକୁ ମାରିଦେଲୁ, ମୋର ଭାଇକୁ ମାରିଦେଲୁ ଓ ମୁଦାଲାମାନଙ୍କୁ କୋର୍ଟରୁ ଖଲାସ କରାଇଦେଲୁ। ମୁଁ ତାର ପୁଅ ବିଜୟ ରାଉତ, ତୋତେ ମୁଁ ଛାଡ଼ିବି ନାହିଁ। ବିଜୟ ରାଉତ ଇଜ ଦ one of the appellant here.
ବିଜୟ ରାଉତ, yes.
ଏହିପରି ଧମକାଇ ସେ ପୁଣି କାରର ବାମ ପାଖ ଆଡ଼କୁ ଆସି ଅମିୟ ବାବୁଙ୍କୁ ମରାପିଟା କରିବାକୁ ଯାଉଥିବା ବେଳେ ମୁଁ ହଠାତ୍ କାରରୁ ଓହ୍ଲାଇ ଆସି ବିଜୟ ରାଉତକୁ ପଛପଟୁ କୁଣ୍ଡାଇ ଧରିଲି। ଡ୍ରାଇଭର ଧରି ଏହି ସମୟରେ ବିଜୟ ରାଉତ ସହିତ ପିସ୍ତଲ, ରିଭଲଭର, ଭୁଜାଲି ଛୁରୀ ଆଦି ମାରଣାସ୍ତ୍ର ମାନ ଧରିଥିବା ଆଉ 3 ଜଣ ଆସାମୀଙ୍କ ମଧ୍ୟରୁ କେହି ଜଣେ ମୋତେ ଜୀବନରୁ ମାରିଦେବାକୁ ଚେଷ୍ଟା କରି ଏକ ଧାରୁଆ ଅସ୍ତ୍ରରେ ପଛଆଡ଼ୁ ମୋ ମୁଣ୍ଡରେ ଆଘାତ କଲା। ଅମିୟ ବାବୁ ସେହି ସମୟରେ ଖୁବ୍ ଯନ୍ତ୍ରଣାରେ ବିଜୟ ରାଉତ ମୋତେ ଗୁଳି କରିଦେଲା, ମାଲୋ ମରିଗଲି, ମୋତେ ବଞ୍ଚାଅ ବୋଲି କାର ସିଟରେ ବସି ଚିତ୍କାର କରୁଥିଲେ। ଏହି ସମୟରେ ପାଖ ଆଖ ଲୋକ ଘଟଣା ଜାଣିପାରି ଆମ ଆଡ଼କୁ ଦୌଡ଼ିବାରୁ ଆସାମୀମାନେ ଫେରାର ହୋଇଯିବା ଉଦ୍ଦେଶ୍ୟରେ ଆମ କାର ପଛ ପାଖେ ଥିବା ସେମାନଙ୍କ କାର ନମ୍ବର ଓ RI 510 ଆଡ଼କୁ ଦୌଡ଼ି ଯାଇ ଦେଖିଲେ ଡ୍ରାଇଭର ନାହିଁ। ସେତେବେଳକୁ ଉକ୍ତ ଘଟଣା ଦେଖି ଡ୍ରାଇଭର ଗାଡ଼ି ଛାଡ଼ି କେଉଁ ଆଡ଼େ ପଳାଇ ଯାଇଥିଲା। ତେଣୁ ଆସାମୀମାନେ ଅନ୍ୟ ଉପାୟ ନ ପାଇ ରାଉରକେଲା ରାସ୍ତାରେ ଦୌଡ଼ି ପଳାଇଗଲେ। ଘଟଣା ଜାଗାରେ ଥିବା ଲୋକମାନଙ୍କ ମଧ୍ୟରୁ କେହି ଜଣେ ଆମର କାରରେ ଅମିୟ ବାବୁଙ୍କୁ ଓ ମୋତେ ତୁରନ୍ତ ଡାକ୍ତରଖାନାକୁ ନେଇ ଆସିଲେ, କିନ୍ତୁ ଡାକ୍ତରଖାନାରେ ପହଞ୍ଚିବା ସଙ୍ଗେ ସଙ୍ଗେ ଅମିୟ ବାବୁ ମରିଗଲେ। ତାଙ୍କର ଡାହାଣ ପାଖ ଛାତି ଓ ପିଠିରୁ ରକ୍ତ ବାହାରୁଥିଲା। ଆସାମୀ ବିଜୟ ରାଉତର ବାପା ଅନନ୍ତ ରାଉତର ମର୍ଡର କେସ୍ ଠାରୁ ଉଭୟଙ୍କ ପକ୍ଷ ମଧ୍ୟରେ ଶତ୍ରୁତା ଥିବା ବିଷୟ ମୁଁ ଜାଣିଥିଲି। ସେହି ଶତ୍ରୁତାରୁ ଏପରି କାଣ୍ଡ ହେଲା। ଅମିୟ ବାବୁଙ୍କର ବର୍ତ୍ତମାନ ଡାକ୍ତରଖାନାରେ ବାରଣ୍ଡାରେ ପଡ଼ିଛି ଓ ମୁଁ ମଧ୍ୟ ଖଣ୍ଡିଆ ହୋଇଛି। ଉକ୍ତ ହତ୍ୟାକାଣ୍ଡ ଘଟାଇଥିବା ବିଜୟ ରାଉତ ଓ ତାଙ୍କର ଅନ୍ୟ 3 ଜଣ ସାଙ୍ଗମାନଙ୍କ ବିରୁଦ୍ଧରେ ଉଚିତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ପାଇଁ ମୁଁ ଆପଣଙ୍କୁ ଜଣାଇବି। ପଢ଼ି ଶୁଣାଇବାରେ ମୋର କହିବା ମୁତାବକ ଠିକ୍ ଲେଖାଥିବା ଜାଣି ଦସ୍ତଖତ ହେଲି ଓ ଏହାର ଏକ ଟୀକା ନକଲ ବୁଝି ପାଇଲି।
So this man is an eyewitness to the other.
Yes.
Apart from this person, who else are the eyewitnesses?
Lordship, another person that Okilo Adia Babu is the PW8.
Achha, so eyewitness.
He was also there at that
Yes.
time.
Eyewitness
But
of
he has-
just a minute. Eyewitness of PW1 or PW8. ठीक था?
Lordship,
Yes. Then dying declaration is there.
no dying declaration.
Yes.
TI parrot.
No, TI paper कहुची मोते मारदेला बोली ये
हाँ माने
spontaneously
death.
बाहर ला for them.
Hmm.
He has stated that
He uttered this.
ना मोते ही माने मार ले तो ईडी मध्य से आई थी वो ये जो कहला नहीं मोते विजय राउत मारदेला बोली
आगे
so that must be also before PW1 and PW8.
Yes.
Lordship.
So
ଡ୍ରାଇଭର ତ ସେଟା କହୁଛି ବୋଲି କହିଲା।
बाकी ଆଉ ଅନ୍ୟ କେହି ଆଇ ୱିଟନେସ୍ ନାହାନ୍ତି।
No.
Who is the doctor who conducted PM?
PW Lordship, medical officer conducted PW12. Dilip Kumar Mishra, medical officer conducted the postmortem examination.
And cause of death is that gunshot injury.
Lordship.
And who is the doctor who examined this PW1?
Same doctor, I think. PW.
Same doctor.
No, PW11.
PW11.
Doctor, yeah, PW11, huh?
PW11
Dr.
examine.
Manoranjan Satpathy.
He examined
Manorama
PW.
Satpathy.
अच्छा.
Dilip Misra wife.
Hmm. So homicidal death aspect is not disputed,
Let's see.
and cause of death is due to gunshot injury is also not disputed, right?
Let's see.
So now the question of acceptance of the evidence of these two witnesses,
Let-
1 and 8.
Let's see.
So what you are telling about PW8?
PW8, though he was very much present in that time of occurrence,
Yeah.
and he has stated that I have not seen any assailant.
He has
I
been
cannot
declared hostile.
recognize any assailant.
No, he has been declared hostile.
No, no.
अच्छा ये हेला तो जणे appellant बाकी अन्य जन ପାଇଁ कोन हैला टीआई पेरेड ହେଇଥିଲା
TI parade conducted after 4 days, but out of 4 assailant, the PW1 could able to identify 2 of them.
no with the magistrate who conducted TA
Conducted a magistrate clerkship
PW10.
PW10. Yes.
PW10 ହେଲା magistrate TA parade ରେ participate ତାହେଲେ କିଏ କଲେ
4 ଜଣ
PW1
ଯାକ
only
କରିଛନ୍ତି। 4 ଜଣ ଯାକ କରିଛନ୍ତି।
participate ମାନେ as identifying witness
Only PW1.
PW1
He could identify out of 4 2.
identifying ହେଲା PW1 has he identified the rest 3 now
Out of 4 2, he identified 2.
अच्छा 2% କାହାକୁ କାହାକୁ
It, that this Vijay Kumar Raut as well as Jagdishwar Rao.
जगदीश्वर राव
Jagadishwar. A. Jagadishwar.
Jagdishwar Rao is now dead
Let's say
and Vijay Raut of course alive.
alive.
Then what about Satyajit Mahapatra, who is the appellant in CRLN number 252? He has been not identified,
No.
not named in the FIR. So on what basis he has been found guilty?
Visually has been seen.
Yes.
Acha.
And he assaulted the foreman.
कोको बेसिस रे अब ओकरा कहउछन आइडेंटिफिकेशन हेई परलानी PW1 just let us be clear PW1 is the only identifying witness. He has named only one person in the FIR and in the TI parade he has identified 2 persons that he has stated, that is Vijay Raut and Jagdishwar Rao. Now so the only they are the appellants in that criminal appeal number 290. ତେଣୁ 252 ର जो 2 जन appellant ଅଛନ୍ତି what he submits that nobody has identified माने PW1 at least he has not identified. ତେଣୁ ତା ଭିତରୁ ଜଣେ ମରିଗଲାଣି ସେଇଥିପାଇଁ ଆମେ ପଚାରୁଛୁ ଯେ ସତ୍ୟଜିତ ମହାପାତ୍ର ୟା ପାଇଁ କ'ଣ ମ୍ୟାଟେରିଆଲ ଆପଣଙ୍କର ଅଛି?
କିଏ କହିଲା?
କିଏ କହିଲା?
ମାନେ who identified that he is Satyajit? नहीं पता सेटा।
Somebody assaulted.
Yes.
What is
There were 4.
There are four, but 2 have been identified. So the rest 2 ରୁ ଗୋଟେ ମରିଗଲାଣି ବାକି ଆମେ ସେଇଥିପାଇଁ ପଚାରୁଛୁ ଯୋଉଟା ବଞ୍ଚିଛି CRLN ନମ୍ବର 252 ତା ପାଇଁ ମ୍ୟାଟେରିଆଲ ଆଇଡେଣ୍ଟିଫିକେସନ ପ୍ୟାରେଡ୍ ଯଦି ନାହିଁ ତାହେଲେ ନା ନାହିଁ ତାହେଲେ କୋଉ ବେସିସ୍ ରେ କ'ଣ ଖାଲି ବୁଝାଲି ରିକଭରି ହେଲା ବୋଲି ତାକୁ 302 ରେ କରିଛନ୍ତି ନା ଆଉ କ'ଣ ଅଛି?
ମାନେ ତାଠୁ ବୁଝାଲି ରିକଭରି କେବଳ ହେଲା ନା ଆଉ ତାଠୁ ଲିଡିଂ ଟୁ ଡିସ୍କଭରି ଆଉ କିଛି ହେଇଛି ନା ଆଉ କ'ଣ? ନା ଲିଡିଂ ଟୁ ଡିସ୍କଭରି ନା କେମିତି? ଲିଡିଂ ଟୁ ଡିସ୍କଭରି। ଆଚ୍ଛା।
So against A1 in CRLA CRA 252 1998 leading to discovery of Ujjal. এইটা আই উইটনেস রহিলে গোটে তো পার্টিসিপেট भी কলানি जो टीआई पैरेड रे PW1 কিন্তু পার্টিসিপেট করথিলা so out of these two witnesses anybody has identified this appellant number 1 in court टीआई पैरेड छाड़ दियो टीआई पैरेड तो কলেনি court identification ହେଇची I'm we'll go through the evidence just one got a preliminary idea of
what outline time
Outline.
so that will go
huh?
এই যে PW1
PW1 identify করছেন এই যে appellant number 1 মানে CRL number 252 সত্যজিৎ মহাপাত্র
বিজয় রাখতে
we are on
প্রশ্ন
Satyajit.
পচার
Vijay Ratra to identified his
বিজয় রাউত ଆଉ ସେ ଯୋଉ ଜଗଦୀଶ୍ୱର ସେମାନେ identified in TI parade କିନ୍ତୁ କ୍ରିମିନାଲ ଅପିଲ 252 ଅଫ 98 ରେ ଯୋଉ ଦି ଜଣ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି ସେମାନଙ୍କ ନାଁ ହଉଛି ସତ୍ୟଜିତ ଆଉ ଯୋଗେଶ୍ୱର ସେମାନଙ୍କୁ TI parade ରେ PW1 ଆଇଡେଣ୍ଟିଫାଇ କରି ନାହିଁ ଏଟା ଠିକ ତ ଯୋଗେଶ୍ୱର ମରିଗଲାଣି ସେଇଥିପାଇଁ ଆମେ ସତ୍ୟଜିତକୁ ପଚାରୁଛୁ ଯେ ସତ୍ୟଜିତ ସିନା TI parade ରେ ଆଇଡେଣ୍ଟିଫାଇ ହେଲା ନାହିଁ PW1 କୁ କୋର୍ଟରେ କାଳେ ସେ ଆଇଡେଣ୍ଟିଫାଇ
PW1 पर ये रे कहला I know all the accused persons केवल I know all the accused persons
ସେତିକି ଖାଲି କହିଛି
that's
So then you come to the one by one eyewitness that PW8 टाको आगे प्लेस कर दो तापरे PW1 को पढ़े आसो कारण PW8 रो आउ किछ नाही
is PW8 is supporting the occurrence only and the manner of occurrence
आसो PW8 को आसो कारण ही प्रथम लाइन टा it helps you that I do not know any of the
accused persons except deceased Amyo Das.
हाँ ସେଇଥିପାଇଁ ତ କହୁଛି ବାକି ପଢି ଯାଆନ୍ତୁ just
On 3/10/96, I had been to the Court of Sessions Judge Sundargarh in connection with a case matter. Sometimes at about 1 p.m., I left the court and went to my hotel, Devasis, named Devasis. There myself to Court of Sessions Judge Sundargarh in connection with a case matter. Sometimes at about 1 p.m., I left the court and went to my hotel named Devasis. Assisting me in the case took our lunch in the Devasis hotel. Thereafter, at about 1 p.m., we came out from the hotel to board our car, of which one Suresh was the driver. He was the PW1, let's see, Suresh. The car was belonging to Amyo Das, deceased. While the driver was on his seat and I was on the left side of the rear seat, deceased Amyo Das came from the other side rear seat. No sooner he opened the door, some person fired at him, for which he leaned over the seat of the car with serious bullet injuries. When the driver came out to save Amyo Das, he was also assaulted by sharp cutting instrument by four persons who were almost close to the car. Seeing all this, I fled away from the spot out of fear, leaving the deceased Amyo Das and driver at the spot. The vehicle was very before the hotel at a distance of 10 to 15 yards. As the distance of 10 yards from the compound of the hotel. Since I was frightened, I could not mark the assailants. Cross-examination by defense except Jagadish Swarna. On that day, I had come to defend the accused of a murder case. Amyo Das was also engaged in that case. As no witness turned up on that day, the said case was adjourned and therefore we had left for the hotel. About 2 to 3 hours after the incident, the police interrogated me in the office of the SP, Sundargarh. Which is also a very important point. My statement was recorded at that place. Thereafter, I was never interrogated by the police. In the hotel, I didn't talk about the incident with anyone. I saw it from the hotel that the deceased Amyo and injured driver were being taken to the hospital by the same car. Then I didn't notice any police officer near the car or near the place. There was congregation of several persons after the incident. I saw 4 of the assailants, but I could not recognize them. I did not talk to any of the assailants, nor I tried to prevent them. Amyo Das simply was saying something, those 4 assailants in Odia language, which I could not understand. He talked so after the first fire. He talked so after the first fire. I have heard sound of 2 bullet fire. Let's see. He has stated 2 bullet fires. Soon after the hearing of the sound, I looked forward and found that Amyo Das was leaning on his seat. I have not seen the first fire, but I have seen the second fire. One of the assault inserted the pistol inside the car and fired at the deceased. By the time of said second fire, Amyo Das was already in the seat of the car. While the deceased was about to enter the car, I heard the first firing sound. Deceased was entering the car facing towards the driver. The deceased Amyo Das, after receiving the first bullet, leaned over the back seat, and his head was resting on the back side of the seat, at which time he was fired at for the second time. After I took my seat in the car, Amyo Das moved from that door towards the door of the right side through the back door of the car. I saw the assailant who fired the second bullet, and also I saw the other assailants who was assaulting the driver with a sharp cutting weapon. I have not noticed the part played by the other 2 assailants. When the driver came out from the seat to help the deceased, I also at the same time opened the door for an escape. The driver was assaulted near the door of Amyo Das. While I was about to come out from the car to go to the hotel, assault on the driver took place. Out of the 4 assailants, only one was having that dragger and was assaulting the driver. He was taking a dragger. I have not minutely observed what type of dragger it was. It may be a chopper or a dragger. The length of the instrument was about 1.5 and 1. The driver was assaulted with that instrument, but not that he was stabbed. I have seen only one assault being made to the driver. I have not observed whether the driver, after receiving that blow, fell down on the ground or whether more blows on the same dagger were given to him, as by then I was proceeding towards the hotel. The driver did not go to the left side of the car. This is also a vital point. The driver did not go to the left side of the car. On the date of occurrence, I shifted from the hotel to the local circuit house in the night, and on the following day I left for Kolkata. So long I was at Sundargarh, I didn't meet the driver. After the incident, I also did not inquire about his health condition. Even after my departure from Sundargarh, I had no occasion to talk with the driver after the incident. This is also very important point. I did not see any mob proceeding towards the spot after I came down to the hotel. I had simply noticed a gathering at the spot. The driver was assaulted between 1 to 2 minutes of the first gunshot. That is, soon after the second gunshot, the driver was assaulted. There was no gathering near the car at the time of first shot, second shot, or at the time of assault on the driver. But at that time, some persons were on the road. At the time of assault on the driver, there was no gathering of mob, but people were coming and going on the road. The driver was assaulted on the road itself. So far I noticed none of the public came forward to save the driver while he was being assaulted. By the time I left for the hotel, the culprits were very much present near the vehicle with their weapon of offense. I immediately rushed inside the hotel and again came out to watch the progress. At that time, I found the gatherings. There is a small compound wall of 2 to 3 feet height in front of the hotel. Therefore, it was visible from the hotel itself. So far, I know deceased Amyo Das was a CPIM worker. When questioned by the court, the witnesses says that he himself is not a worker of CPIM party. Deceased had been to Calcutta and then I was entrusted with the case. Amyo Das was not known to me earlier until he entrusted the brief to me at my office at Kolkata. I had not discussion with the deceased regarding the political matter concerning CPIM. The only discussion I had with him was with regard to the case matter. One Ananta Raut was the deceased of that case in which I was to appear for defense. It is not a effect that deceased Amyo was a friend of mine and that his antecedents are quite known to me. I cannot say if deceased Amyo had political rivalry with any persons. It is not a fact that the manner in which I narrated the story is not correct, the same being a concocted one. Cross-examination for Jagishwar Singh. The distance between the car and the counter of hotel is about to 10 to 12 cubits. I within no times could reach the counter. There was telephone facilities in the counter of the hotel. I did not inform the police over phone, but hotel manager informed the same. I do not know, of course, to whom did he inform. The hotel was just 64 the side of the main road.
Just by the side of.
By the side. So it was not properly. There are shops on either side of the road. The deceased Amyo Das reached the car about 2 to 3 minutes after I took the seat. By then, I had not noticed the assailants. I had seen the assailants when they were standing just touching the car. I cannot describe the posture in which the assailants were standing. I had noticed only 4 assailants soon after I heard the first firing sound. Then they were close to the car. It is not a fact that I had noticed more than 4 persons near the car by the time I heard the bullet sound. The car was facing towards the SP office, that is towards Jharsuguda. It is not a fact that I did not like to telephone the police as because I had seen no incident. Prior to me, Advocate Sri Nitish Nanda Adhikari, an advocate of Calcutta, was entrusted with the brief. The said Adhikari was law minister under CPIM government in West Bengal. It is not a fact that I am deposing falsehood as because deceased belong to CPIM to which I am belong.
So, Mr. Pradhan, we are asking you that if PW8 was present with PW1 at the scene of occurrence and as seen, why no test identification parade was conducted, taking this PW8 as an identifying witness? What explanation is there? because you have already conducted TA parade and PW1 participated. So why PW8 was not taken as an, because he has not prior acquaintance with the accused persons who committed the. As from the evidence, he has stated everything, how the occurrence took place, and that almost corroborates the evidence of PW1. So you could have got another supporting evidence from PW8, but the very first line, it indicates that I do not know the accused person. Any explanation has come that why no TA parade, he did not participate in the TA parade? Huh?
So much I can.
Or no?
He got frightened. No, you say right from the beginning, a person is a lawyer coming from Calcutta. There is no scope otherwise. How could he know them? But from the gesture, posture, appearance, whether there was any opportunity for him to see the or identify the assailants. So that has to be seen from the TI parade. No? Whether similar person was there or not, not that he must be knowing them.
TA parade knowing TA parade
କାଇଁ ହବ?
କଣ ତାକୁ ପୁରା କ୍ଲୋଜ ରୁ ଦେଖିଛି ନା ସେ କାର ଭିତରେ ଥିଲା ସେଇ ପାଖରୁ ଦେଖି ସବୁ ଡିଟେଲ ମଧ୍ୟ କହୁଛି ତ ମାନେ ଏନି ଆଇଓ କିଛି କହିଛି ଯେ କଣ ପାଇଁ ସେ ପ୍ରେୟାର କଲାନି ବିଫୋର ଦି ଟିଆଇ ପ୍ୟାରେଡ ମାଜିଷ୍ଟ୍ରେଟ ଯେ ଏମାନଙ୍କୁ ଆକୁ ମଧ୍ୟ ଆଇଡେଣ୍ଟିଫାଇଂ ୱିଟନେସ୍ ହିସାବରେ ବିକଜ ଆଟ୍ ଦି ରିକ୍ୱେଷ୍ଟ ଅଫ ଦି ଆଇଓ ଦିସ୍ ଇଜ ବିଂ ଡନ୍ ସୋ
କରିଥିଲେ ସେ ଆସିଲେନି କଣ ହେଇଛି?
Have you
examined that part?
Note it and study the brief accordingly. Our pertinent question is that why PWA did not participate in the TI parade which was conducted by PW10 as an identifying witness. Hala? Whether because we have read the entire evidence of PW8, he has never stated that the IO made any such request to him to participate in the TA parade. He has not stated. So whether IO has stated anything, right? That you study. You have prepared it. IO koichi kisi? IO se bisare?
No.
Fine. So ei jo PW8 ର version ku jodi ame dekhibu occurrence bisare chali asuchi. Jemti 4 jana lok asle ya kale emti kale bas. Now you come to then PW1, which now becomes the star witness of the case.
The PW8 stated that 2 bullet sound.
No, those are also come to the
PW1 page 106.
yeah. You see, he is an injured person.
That's it.
So his presence at the scene of occurrence is very difficult to be dislodged.
That's it.
So question is that he has also identified 2 persons. Both are the appellants in one criminal appeal.
That's it.
So now see that what he has stated. Please read it out.
That's it. I know all the accused persons who are standing in the dock. I know deceased Amyo Das. This occurrence took place on 29/10/96 in front of Devashish Lodge. I had brought deceased Amyo Das and one advocate of Kolkata to in a car from Devashish Lodge to the court premises of the Sundargarh. At about 12 a.m., I had taken both of them in the car from the court premises to Devashish Lodge. Amyo Das, deceased, told me that he would return to Raurkela at 1 p.m. I was staying in room number 35 of Devashish Lodge. But see, this is an important point also. I went to my room. I brought the attached and files from that room and kept the same in the car. I was sitting in driver's seat inside the car.
Adiya Babu, advocate.
PW8. Advocate came to the car and sat on the left side on the back seat. About 5 to 7 minutes thereafter, Amyo Das came from the lodge. He came to the left side of the car for sitting inside the car. Adhya Babu told Amiya Das to sit on the right side. While Amiya was going to sit on the right side, somebody came and fired at the chest of Amiya Das. Somebody came and fired. Accused Vijay Raut, standing in the dock, fired at the chest of Amiya Das by a revolver. At that time, Amiya Das shouted, "Malu, मते बंचा विजय राउत मते गुली मारे." Thereafter, accused Vijay Raut assaulted Amiya Das on his head by a revolver. Head रे मध्य मारिची बोली revolver आसला. From the left side,
From the left side.
I caught hold of accused Vijay Raut. Accused Rao identified dealt visually blows on my head. He has stated
Accused नाने.
Jagdish
Hold
Rao.
of accused Vijay Raut.
I caught
Appellate
hold of
number
accused
Jagdish
Vijay
Rao.
Raut.
जगदीश जोड़ा मरी रहा है.
हाँ विजय राउत को धरिला बेले accused राव आसिकी ताकू
हाँ, ठीक है।
भुजाली रे blow
मारिला
ठीक है.
On his
on
head.
his head.
हाँ.
से identify कला मध्य राव को.
Okay. He is dead.
Other persons came running to the scene of occurrence, and on seeing them, the accused persons left that place
And went near
went near their car.
car.
Vijay Rao told, "ମୋ ବାପା କୁ
ମାରିଥିଲ
ମାରିଥିଲ, ମୋ ଭାଇ କୁ ମାରିଦେଲ,
ମରେଇଦେଲ
ମରେଇଦେଲ, କୋର୍ଟରେ ମୁଦାଲା ମାନଙ୍କୁ
ଖଲାସ
ଖଲାସ
କରିବା
କରିଦେଲ." ଆଉ ତାକୁ କଣ ଲେଖା ହେଇଛି?
ମୁଁ ତାର ପୁଅ
ମୁଁ
ବିଜୟ
ତାର
ରାଉତ।
ପୁଅ ବିଜୟ ରାଉତ ତତେ ଛାଡ଼ିବି ନାହିଁ.
ହୁଁ,
Their driver was not present in the car,
ହୁଁ,
and he had gone away somewhere else.
ହୁଁ।
The driver of the accused
Other,
car,
yes, yes.
the registration number of that car was ORE 510. That car was parked behind our car.
Yes.
The accused persons fled away towards Raulkela. Some people took me to the hospital. Amiya Das was also taken to the hospital. I remained in the hospital for treatment. Police came to the hospital. I orally reported about this incident before police, who reduced into it writing. The contents of the report were read over and explained to me. Exhibit 1 is my report and Exhibit 1 by 1 is my signature. I had identified in the TI parade accused Rao and Vijay Rao.
They are the appellants in that 290.
Yes.
No, Lord.
290. 290.
Yes.
I got sick. I had identified in the TI parade accused Rao and Vijay Rao. During investigation of this case, police seized my shirt and ganji and prepared seizure list in my presence. Exhibit 2 is the seizure list and 2 by 1 is my signature. I stayed in the hospital for 3 days for treatment. Cross examination for Vijay Raut. I was facing in the front.
I was facing to the front
to the
sitting.
front, sitting in the car seat, in the driver's seat.
ତାକୁ ପଢିବେ ସେମିତି I was facing to the front, sitting in the driver's seat. Then only you can get the meaning of it.
I was facing to
How
the
to
front,
read it?
sitting in the driver's seat.
Driver seat रे बसी मु आगु
Absolutely. That is the
that is the meaning. हाँ.
Amiya Das opened the right side door of the car and entered inside the car.
ପଛପଟେ ଯାଇକି ସେ right
Right
side
side
ଇଏଟା
ବସି.
ଖୋଲିଲା.
At that time, I looked behind. At that time, I saw 4 persons. Accused Vijay Raut fired the bullet from the revolver, keeping the revolver on the chest of Amiya Das.
yes.
Vijay Raut was standing outside close to the door. I came down from my seat after the firing. By that time, I had already
He had already gone
sorry. By that time, he had already gone to the left
left
side.
side.
Accused has already gone. Other persons were standing behind the car. After getting down, I went to the left side. At that time, accused Rao assaulted me by a bhujali. Accused Rao assaulted me by Bhujali when I caught hold the accused Vijay Kumar Raut on the left side. Left side door of the car was open by that time. All these events took place within 2 to 3 minutes. Advocate Adia Babu went away from the car when accused Vijay Kumar Raut came to the right side door of the car. On that day, I had met Adia Babu inside Devashish Lodge Hotel. I met Adia Babu in Devashish Hotel after this occurrence on the same day. This is the important point. I did not know the accused Jagadish Rao prior to this occurrence. I also did not know accused Vijay Kumar Rao prior to this occurrence. I also did not know accused
କାହାକୁ ତ ଜାଣିନି ବୋଲି କହିଲା ଚାରି ଜଣକୁ
Jogeshwar Suna Satyajit Mahato prior to କାହାକୁ ଜାଣିନି ଜାଣିନି. Accused Jagadish Rao assaulted me from my backside. I have seen accused Jagadish Rao looking to the backside at the time of assault on me. I have seen accused Jagadish Rao while he was assaulting me by Bhujali. I have seen that. At that time, 2 other accused persons were also standing there. There are many shops near the place of occurrence. No shopkeeper or outsiders had come to the place of occurrence when this occurrence took place. Many outsiders had come to the place of occurrence before I was taken to hospital. I do not know them. Amya Das was lying on the back seat and his body was tilted towards left. The head of Vijay Raut was inside the car and his legs were outside. I had noticed blood stain lying on the seat. I was in sense when I was taken to the hospital. I was able to walk and talk at that time. The doctor examined me in the hospital. No police was present when I was examined by the doctor after reaching the hospital. The doctor examined me and gave medicine. The doctor did not ask me anything about this incident, nor I stated anything before the doctor about the incident. It's important. I reached the hospital at about 1:30 p.m. and police came to hospital at about 2 p.m. I orally reported about this incident before police in the hospital. Subsequently, I was not examined by the police. See, this is important. Subsequently, I was not examined by police. I have not stated before the police the name of accused Rao while giving oral report about this incident in the hospital. I was working as a driver under Amya Das for a year. Prior to this incident, Amya Das was a CPM leader.
As a driver under Amya Das for a year prior to this incident. Stop.
Sorry.
Amya Das was a CPM leader.
Sorry. Amya Das was a CPM leader. I cannot say if Amya Das was not pulling on well with other leaders while he was leading the CPM. I cannot say if Amya Das was involved in many cases. I had identified accused Vijay Kumar Raut and A. Jagadish Rao on 30/10/96. TI parade has happened 2/11. ये कहला जे I have identified them 30/10/96. I cannot say if accused Jagadish Suna and Satyajit Mahapatra we are present at the time of TI parade, as I could not able to identify them out of 40 to 50 persons who were standing for the purpose of identification. I had stated before the magistrate that I had seen Vijay Kumar Raut while he was firing bullet from the revolver. I have also stated before the magistrate that accused Jagadish Rao assaulted me by a Bhujali. I came to know the name of accused Jagadish Rao from him on the day of occurrence, as he gave out that his name is Jagdish Rao. After the assaulting, accused Jagdish Rao disclosed that his name is Jagdish Rao. I have not stated at the time of lodging FIR that accused Jagdish Rao disclosed his name after assault. I have not named accused Jagdish Rao at the time of lodging FIR. After lodging the FIR, I have not stated the names of accused persons before the police. After lodging the FIR, I have not stated the names of accused persons before the police. I saw the accused persons on the day of occurrence, and thereafter I saw them in the TI parade, and thereafter I am seeing them today in the court. Accused Vijay Kumar Raut placed the revolver on the right side chest of Amiya Das while he was sitting. He was facing to the front side. Accused Vijay Kumar Raut placed the revolver straight on the right side chest of Amiya Das. This incident within, I saw this incident within inside the car. I heard the sound of bullet while I was sitting inside the car. I have seen at the time of firing. It is not a fact that I have not stated before the police that I have seen firing. I have not given the description and features of the accused persons who had taken part in the alleged occurrence in my affair and statements. Subsequently, accused Vijay Kumar Raut gave a blow on the head of Amiya Das on the backside of the revolver. In car in which Amiya Das had come was seized by the police, and it was released 4 days after the prior to this incident. Car was released in my custody. There was blood stain on the seat when it was released. There was firing only for once. He admitted there was firing for only for once. Firing age. After discharge from the hospital, I went to Raulkela. It is not a fact that the accused persons were not present at the place of occurrence. It is not a fact that my statement is in examination in chief are false. It is not a fact that accused Jagdish Rao had not assaulted me by brutally and that I am deposing falsehood. Wife and brothers of Amiya Das were alive. I had no knowledge regarding murder of father of accused Vijay Kumar Raut. It is not a fact that I have fostered a false case against the accused person at the instance of the wife and brother of the Amiya Das. I was taken in the car to the hospital. I do not know the name of the person who had taken me to the hospital. They came to the spot after the occurrence. They did not ask me anything. I did not tell them anything about this incident. I had not stated about this incident before any other person till today. Cross-examination for accused Jagdishwar Sunna. Now I am staying in Badbil. I have come today to the court after receiving notice. I was noticed to attend the court on 5/11. I had come alone today in bus. I received notice at Koida. After return from the court, Das Babu told me for going to Raukela after taking food. My car was facing towards Sundargarh. There are many shops near Devashish Lodge. This lodge is situated adjoining Sundargarh to Raukela Road. It is at the time of occurrence, vehicles were plying on that road and the police were also going on that road. Sorry, the people were also going on that road. I cannot say if any other vehicle were parked near the lodge at that time, but many vehicles were plying on the road. There is a motor garage near Devashish Lodge. I cannot say if any vehicle was standing near the garage. I saw accused Jageshwar Sunna on the date of occurrence at the place of occurrence. It is not a fact that I am seeing deceased, I am seeing accused
Jogeshwar Sona.
Jogeshwar Suna for the first time today in the court. It is not a fact that I am deposing falsehood.
Anigiri announcement to proceeding. Let them ride and
So, Mr. Pradhan, we have gone through the eyewitness statement. How do you justify the conviction of Satyajit? The appellant in criminal appeal appellant number 1 in criminal appeal number 252 of 98. So far as evidence of that PW 8 is concerned, it is totally nil. He had not seen, he said that I do not know the accused person. Now then comes only PW1. PW1 has neither stated his name, nor even identified him TI parade, nor even in court also. So on what basis you found them guilty, unless the identity of there were some other persons with the persons who committed the crime. But unless you establish their identity to be the Satyajit Mahapatra, how the conviction will be sustained? We do not know how
We are caught red-handed.
caught red-handed. Who has stated?
Who has stated?
अरे ये भी जहाँ तो किसी नहीं सेमती caught red-handed ମାନେ କୋଉ
ମାନେ ୟାଙ୍କୁ ହସ୍ପିଟାଲ ନବା ପୂର୍ବରୁ ତାଙ୍କୁ ଆଗେ ଧରିଦେଲେ ଲୋକାଲ ଲୋକ ନା କଣ?
लोकल लोग आगे
Who has given this statement? How do you bring Satyajit within the
stated by
ସାକ୍ଷୀ?
सब ଏଇ ଯୋଉ ଦି ଜଣ ବର୍ତ୍ତମାନ ୱିଟନେସ୍ ଏକ୍ସାମିନ ହେଲେ PW1 ସେମାନେ କେହି କହୁନାହାନ୍ତି କୌଣସି accused apprehended ହେଲା at the spot, rather they have stated that after committing the crime they fled away. ଦେଖିଲ ତ evidence ଦେଖିଲ ତ ଆଉ ଯୋଉ ଧର ଆପଣ ଯୋଉ କହୁଛନ୍ତି at the instance of let us say ସତ୍ୟଜିତ ମହାପାତ୍ର ଗୋଟେ କଣଟା ଗୋଟେ ଜବତ ହେଲା ବୋଲି କହୁଛନ୍ତି ଭୁଜିଆଲିଟା ହଁ ପରେ ଜବତ ହେଇଛି ଯଦି ଏହା ବି ହୁଏ ମାରିଛି ରାଓ ମାରିଛି ରାଓ ତାହେଲେ ସେ ଭୁଜିଆଲିରୁ ଆପଣ କଣ ମିଳିଲା ଯେ ଏମିତି ତାକୁ 302/34 ରେ କନଭିକ୍ସନ କରିଦେବେ? Anything found out from
Any other circumstance have you come across any other circumstance? Because the case is based on primarily the direct evidence of eyewitness account. Whether there is any other circumstance to embroil the other accused, appellant. No, you have to see whether you have. Then what is how he has been involved, how he has been convicted.
ହଁ ମାନେ ରିଜନିଂ କଣ ଦେଇଥିବେ ତ
ତଳ କୋର୍ଟ ଟ୍ରାଏଲ କୋର୍ଟ କଣ ଅଛି?
PW1 ଆଉ PW8 ଟୋଟାଲି କେହି ମାନେ କହିବି ନାହାନ୍ତି ତା ନାଁ ନାହିଁ ଆଇଡେଣ୍ଟିଫିକେସନ ନାହିଁ କୋର୍ଟରେ ନାହିଁ ତାହେଲେ କୋଉ ବେସିସ ରେ ତାଙ୍କୁ କନଭିକ୍ସନ କଲେ ତା ତ ଗୋଟେ କାରଣ ଦେଇଥିବେ ନା। Please confine to Satyajit only. Para 99 କେତେ page କୁହନ୍ତୁ?
Page 56.
56. ପଢ. As regards the accused Satyajit. ପଢ.
As regards accused Satyajit Mahapaତ୍ର, IO further said that this accused had also given discovery of the weapon of offense pursuant to its statement recorded under Section 27 of the Evidence Act. According to him, said accused led the police to the Khamripara shop situated on the road heading from Sundargarh to Raipur and gave discovery of the iron bhujali fitted with the wooden handle from inside a bush situated by the northern side of the road leading to Raipur. Remove one is the bhujali and exhibit 26.1 is the scissor list under which it was seized. The evidence of the IO further showed that the place from where accused Satyajit Mahapatra gave discovery was also on the way in between the place of firing and the jungle from where the accused persons were apprehended. According to the IO, these recovered articles, together with the wearing apparel of the deceased and that of the injured informant and the bullet which was collected from the body of the deceased, were sent to the RFSL Anthapoli, Sambalpur for the test of chemical examination. His evidence further showed that for the purpose of investigation, he had also requisitioned the service of the DFSL Raulkala for scientific investigation. Period 13, the scientific officer has stated that as per requisition of the IO, I came to the police station on GBC 10 with a team of officers and visited the spot and examined the articles seized by the police. He also says to have examined the ambassador card with serial number 05A1867 in which the deceased was shooted, and another card serial number ORE 5110 which according to the prosecution was brought on hire by the accused person. The scientific officer further said that as some chance fingerprints were in the car OR 05A1867. It took photograph of the same collected saline extract of blood available on the rear seat of the said car and marked it with the letter P and gave the mark 1 by P by 1 to the sample cloth of the cloth. He further said that he took extract of the hand of accused Vijay Kumar and A.W. Sora by means of gauze cloth and marked it as C and T respectively, and the sample cotton as E. He further said after collection of all this, he advised the police to send the cell for better attention at RFSL Pointapil Suburb, and that he himself sent the fingerprints to all the accused persons to the director of fingerprint expert, Mr. Bhubaneswar, along with transcripts which he had taken from the body of the victim, OR 05A1867. The evidence of the scientific officer further shows that at the police station, he had also examined all the weapons of offense and bullets which were police had seized. The witnesses further said after examining these items, he advised the police to send the firearms and the bullets to the Deputy Director RFSL Sambalpur for biological and ballistic opinion and report. According to him, MO2 is the revolver, MO3 and MO5 are the continued pistol which are for him for his examination along with other sheet articles.
So let us say that even if the IO's evidence is accepted, and at the instance of this appellant number 1, Satyajit, one Bhujali was recovered on the basis of the statement recorded under Section 27. But unless you connect this Bhujali as the weapon of offense used in the crime, then again, how do you establish his complicity? From the C report, it appears that kind of bhujalita use karnothila according to this PW1. It was not used by any unknown person. It was used by that man who was Rao, who is dead now. ତେଣୁ ଯଦି ମନେ କରନ୍ତୁ ରାଓ ଠୁ ନେଇକିନି ଇଏ ଗୋଟେ ନୁଚେଇ ଦେଇଛି ଲେଟେଷ୍ଟ ସେ ତାହେଲେ ମ୍ୟାକ୍ସିମମ୍ ହେଇକିନି 201 ପର୍ଯ୍ୟନ୍ତ ଯିବ ବଟ୍ ହାଉ ଡୁ ୟୁ convict him under 302 by 34 IPC or 307 even 34 IPC. 307 obviously से जो PW1 ପାଇଁ ହେଇଛି ଆଉ 302 ତ disease ପାଇଁ ହେଇଛି ତେଣୁ ସେଇଥିପାଇଁ we are repeatedly asking you that जो ଲାଇନ୍ ଟା ପଚାରିଲେ that
ground ଟାକୁ ଦେଖିଲେ trial court is giving one circumstance to bring these appellants within the ambit of 34 because they were found together and they went together. That's all. They, after the occurrence, they ran together and that only brought these people within the ambit of 34.
Who has stated that? Who has stated that they came together and ran together? ଆମେ ଦେଖିଲେ 1 number ତ 4 number
any witness is speaking about that.
4 ଜଣ ଲୋକ ଆସିଥିଲେ
that is there.
କାମ କରିକି 4 ଜଣ ଲୋକ ପଳେଇଲେ ଏ ଏଭିଡେନ୍ସ ଅଛି ସେଇ 4 ଜଣଙ୍କ ଲୋକ ଭିତରେ ଏଇ ଯୋଉ ସତ୍ୟଜିତ ଥିଲା ଯୋଉଟା କି
nobody has stated this.
ट्रायल कोर्ट क्लारिफाई करछि पारा 25 रे पेज 62 रे
ପାରା 25 ରେ
पेज 62 categorical statement may I read as regards the involvement of accused Jagdishwar Sunna, the evidence of informant and that of PW8.
ଯୋଗେଶ୍ୱର ଆମ ଦରକାର ନାହିଁ
ତା ତଳକୁ ଆସିଛି the PW8, the advocate of Kolkata, needs further repetition. From their evidence, it is clear that accused Vijay Rao and the others having appeared unexpectedly near the car and fired at the deceased, and that when the driver PW1 tried to prevent accused Vijay Kumar Rao, he was assaulted from his back by one of the accused. According to P1, he was assaulted over his head by means of Bhujali by a Jagdishwar Rao. Since the said accused has given discovery of some other articles other than Bhujali, it was argued by the defense that the evidence given by PW1 that he was assaulted by accused Jagdishwar Rao cannot be believed. It may be noted here that the above statement of PW1 is first of all not in conformity with his earlier statement made before the police. Besides, his evidence discloses that by the time he turned back on receiving the injuries on his head, he found accused Jagdishwar Rao and another standing behind him, and by then he noticed the Bhujali in the hand of a Jagdishwar Rao. The above circumstances as disclosed by PW1 shows that perhaps the assailant standing behind the accused a Jagdishwar Rao had really given the blow, but it has appeared to the witness as if the same was given by.
So this is a description given by the court on its
by confusion लिखिछन
माने के जे डायरेक्ट एविडेंस देला he was under confusion said the name of Rao, whereas this is the man who had given according to the court. But whose evidence is this?
ଯଦି ବି ଗୋଟେ ଭୁଜାଲିଟା ଇନଷ୍ଟାନ୍ସ ରେ ଜବତ ହେଇଛି ଏବଂ ସେ ଭୁଜାଲରୁ ହ୍ୟୁମାନ ବ୍ଲଡ ବାହାରିଛି ବୋଲି ସି ରିପୋର୍ଟ ହଉଛି again question is that unless you link it to the
लिखिछंती
when the Bhujali has been recovered at the instance of Satyajit Mahato.
कोण
when the Bhujali has been recovered at the instance of Satyajit Mahato, the evidence of PW1 which he has disclosed before the court that he was assaulted with Bhujali by accused Jagdishwar Rao can only be considered to a mistake committed.
Direct evidence is a mistake and the
serious notice of the case can be taken. Court कहले
assumption ଆସିଗଲା
सो डायरेक्ट एविडेंस रे से जन को इम्प्लिकेट करछि ये प्रिजम्पशन ने कि थर्ड को नहीं कि ताकू कोन करले
So 27 leading to discovery, one witness is there.
हां who what he has said
He has been hostile. PW 16.
So only, that means only basing on the IO that has been done.
Let's see, it's a peculiar case. Let's see, in
IO evidence को आसिले
PW 18.
से जो भुजियाली कथाटा पड़े आछन PW 18 जो भुजियालीटा को लाइन एविडेंस है
ये पारा 5 रु आरंभ कले सर.
नहीं थी भुजियाली कथाटा आसुन गोटे भुजियाली पर डिस्कशन होची तानारा आ किछि नाही
बुझाली पारा 8 163. पेज 163.
163
Let's see. Right. Accused Satyajit Mahapatra.
पढ़ो
Accused Satyajit Mahapatra, pursuant to his statement made under Section 27 of the Evidence Act, led us to the
हमारी पड़ा छक्का हाँ.
Hamari Pada Chakka, situated on the road leading from Sundargarh to Rautla, and gave discovery of an iron bujari fitted with a wooden handle from inside a bush situated by the side of the road, on the northern side of the road, leading towards Rautla. MO1 is the bujali, which I seized via 26 by A and 26 by 2, 26/3 at the signatures. The article seized under 23 by 1, 24 by 8, 25 by 1 were witnessed by some witnesses, Pradeep Kumar Sahu and Rajesh Dalwani, while making seizure of article under 26 by 1. Witness Rajesh Dalwani has already left, and therefore the said seizure was made in presence of witness Pradeep Kumar Sahu and another
Kapur
Chand Sahu.
MO1 टा होची से जो भुजियालीटा
Lordship.
that has not been identified by PW1
No.
ताले तो लिंक टा जो हमें पचारुछु हाँ खाली गोटे लेटस से गोटे ह्यूमन ब्लड रो थिबा गोटे भुजियालीटा at the instance of this Satyajit was recovered. Question is that तारी basis रे unless you establish any link with the crime, link crime रे establish करथांते दीटा लोक बेस्ट लोक होचंदी एक या 8 जे ही गोटे भुजियालीटा में देखितलु आ हाथे रे तो से एविडेंस नाही डिसीज रो ग्रुपिंग बेली आपण ग्रुपिंग ती बाहर करना तेणु खाली ह्यूमन ब्लड बेची तेणु तारी बेसिस रे ए जो रीजनिंग टा देले जा पछरे रहि जाइतिबो से देखि नथिबो से तो आई विटनेस निजे कहूची मु देखिची मारिची मते
मारला बेलको देखिछि दूसरे मारछि देखिछि
एते क्लोज डिस्टेंस रे देखि जाओ ये हाइपोथेटिकली जोटा ऑब्जर्व करूचंदी जे ता हाथे रे थिबो ये देखि नथिबो इट्स अ गोटे थर्ड केस मेक आउट करछन ना
ब्लड ग्रुप टा भी ये ही नहीं सी रिपोर्ट रे किछि नहीं
सी रिपोर्ट खाली ह्यूमन ब्लड बोली जा जजमेंट रे लिखा
देयर इज नो ग्रुप
वेयर इज दैट जजमेंट सी रिपोर्ट in paper book number page number forwarding report ता तो होची
एटा होची 199
193 रे
199
199 हां 199 राइट सेट पड़े आसंतु रिजल्ट ऑफ द एग्जामिनेशन पिस्तल छाड़ दियंतु बुझियाली आसुची केते नंबर 202 की
One Vujali के
बुझलेला के रिजल्ट ऑफ के ब्लड मॉडरेट ह्यूमन नो ओपिनियन डिटेरियोरेट इट 204 डिटेरियोरेटेड कितना
हां
पैलेट रे बी ग्रुप अछि सार्ट रे बी ग्रुप अछि सबुतरे बी अछि ह्यूमन बी बी किंतु एटारे नाही
माइनस के
ये हां के रे किछ नाही ब्लड
204 नंबर पुस्तक Ujjali blood, moderate, human, no opinion. Deteriorated.
What we intend to say that what is the nexus, even if this 27 is accepted, that a recovery has been made, how you connect it with the crime?
There is also no charge under section 201.
No.
No. Yes, that is so far as Satyajit. What about that other man, that Vijay? How do you challenge it? He has been identified. His name is there, uttered by the deceased, who is a known person to him.
Yes.
And in court also he has stated. So why the evidence of PW1 would be disbelieved so far as the appellant Vijay is concerned, when the corroborating evidence like the medical evidence also indicates that it is a gunshot injury, and even the C report also
Yes.
indicates that the bullets which were recovered, that was also
Bloodstain with
blood
group.
stain proof, same B group. So
Let's see, so PW1 is a injured witness,
yeah,
eyewitness.
yeah.
Let's see, the TI parrot. First, I want to highlight, let's see.
TI parrot identify kala?
Identified, he has identified the TI parrot.
Yes.
Let's see, in this case, what happened? After the accused persons were apprehended, they first, police, the IO took all the accused persons to the hospital. From hospital, they went to the police station. And they
Examination is necessary.
Sorry?
Examination is necessary.
Necessary. But examination, again, they have come to a hospital in the night time. This occurrence taken place at 1 o'clock around, 1 to 2 o'clock. Let's see. 2 o'clock, IO went to the hospital.
No,
Have
you brought out anything
In the
from the mouth of
cross-examination.
PW1 in the cross-examination that he had got the scope to see this appellant Vijay prior to TI parrot, either in the hospital, as you say, or at any other places?
But then he had seen him closely.
Let's see.
He had seen him because he caught hold of him tightly.
Let's see.
And he had seen him
Let's see.
giving the bullet injury to the
Let's see.
deceased.
Let's see.
So everything he had seen.
Let's see.
So he had seen the person with appearance, gesture, posture, everything. It's a matter of that day, you were saying. Even if on that day he was again brought, the accused was brought before the witness on the very day. Because after that he is saying that I have not got. I saw them only in TI parrot.
He has stated that. Let's see. What happened, let's see, in this case, in the 313 statement of the accused, if I go come to the accused 313 statement, Vijay Kumar Raut, he has categorically stated all these facts. That,
What he has stated?
page 34.
Accused statement for तार Sahoo Hon'Ble.
That is judgment removed.
ନାଇଁ ମୁଁ ଏଇଟା ସେ ଲେଖିଥିଲା ଯୋଉଟା କହୁଛ ଚିହ୍ନଟ କରିଥିଲା କିନ୍ତୁ ତା ପୂର୍ବରୁ ମତେ ମେଡିକାଲରେ ତାଙ୍କୁ ଦେଖାଇ ଦିଆଯାଇଥିଲା TI parrotରେ ମୁଁ ଆପତ୍ତି କରିଥିଲି ଏଇଟା
ଆଜ୍ଞା
No, that is yours.
that is there.
But you have not brought out anything. Rather, in the cross-examination, by ଇଏରେ କହିଲେ ଯେ ଘଟଣା ପରେ ମୁଁ ତାକୁ TI parrotରେ ଦେଖିଲି, TI parrot ପରେ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଦେଖୁଛି କୋର୍ଟରେ ଡିପୋଜିସନ ଦେଲା।
ଏଇ ଯୋଉ ଡିଫେନ୍ସ ନେଲେ ୟାକୁ ପ୍ରଶ୍ନ ଆକାରରେ ପଚାରିଥିଲେ କି ସେଇଠି ତାକୁ?
One thing we have asked that PW1 stated that I have seen that page 1110, para 11, I had identified accused Vijay Kumar Raut and A. Jagdish Raut on 30/10/96. The incident happened 29/10/96. TI parrot occurred on 2nd of November. But he has stated, I had identified.
Under what circumstance this question was put, that is also to be seen, because a stray sentence, the incident happened on 29th and a stray sentence.
Only once the TI parrot was conducted, and it is conducted by none else than the SDGM Sundargarh.
That's it.
PW
Yes.
10 is the SDGM Sundargarh.
Mm.
He has stated that I conducted the TI parade on 2/11/96. The question of conducting
Does-
TI parade on any date does not arise. So maybe that is inadvertently he has stated like that, but specifically stated that all these four accused suspects
Mm.
were present, including that Satyajit also,
That's it.
and who participated in it. He has stated that you come to page number 133.
That's it.
TI parade magistrate.
That's it.
So 2/11/96 specific date he has given. Conducted TI parade, suspect ले 4 जन, district jail Sundargarh रहला 3टा बेले PW1 was summoned through court was present. Is served me summons, तापरे so वाला. बाकी तापरे then he stated specifically next page रे whom he identified. Now he identified suspect Vijay Kumar Raut and A Jagdishwar Rao. दी जनों को चिन्हित है एवं specific line तापर गोटे line देखो witness however could not identify the other two suspects, namely Satyajit Mahapatra and Jogeshwar Naik. Very clear.
Instead of identifying them, he identified two other UTPs.
Leave it. So, ସେଥିପାଇଁ ତ କହୁଛୁ ସତ୍ୟଜିତ ପାଇଁ, but we are now concerned with this Vijay Raut. Vijay Raut ପାଇଁ, apart from the evidence of PW1, TI parade evidence, and the most important is the dying declaration.
That's it.
Right? He has ordered, he knew that man.
Yes, yes.
The deceased was well aware about Vijay Raut because of this litigation, etc. And he uttered these words. So that can be used as the dying declaration also, oral dying declaration. And that is mentioned from the very first point of time in the FIR.
That is the last word uttered by him before his death.
That's it.
So this man is on bail now. This is Vijay.
That's it. Yes.
Lekhon. Criminal appeal number 252 of 1998 and criminal appeal number 290 of 1998. Satyajit Mahapatra and Jogeshwar Sona are the appellants in criminal appeal number 252 of 1998, and Vijay Kumar Rao and A Jagdishwar Rao are the appellants in criminal appeal number 290 of 1998. Jogeshwar Sona of criminal appeal number 252 of 1998 and A Jagdishwar Rao, appellant in criminal appeal number 290 of 98, are dead, and as per order dated 10/9/2024, the appeal has abated so far as those two appellants are concerned. Stop. The four appellants, including the two appellants for whom the appeal has abated, face trial in the court of London, Session Judge Sundargarh in Sessions trial number 47 of 1997 for offences punishable under section 302 by 34 of the Indian Penal Code for committing murder of Amiya Das, bracketed Lekhantu, hereafter the deceased, on 29/10/1996 at about 1 p.m. at Sundargarh bus stand in front of Devasis Lodge. They were further charged under section 307 by 34 of the IPC for attempting to commit murder of Suresh Purthy, bracketed PW1,
MD Suresh
MD Suresh Purthy,
Pushti. MD Suresh Pushti.
Pushti, the informant in the case,
Besides the offense, 25
and beside the offense under section 25 and 27 of the Arms Act. The London Trial Court filed judgment and order dated 26/9/1998 found the appellants guilty of the offences charged and sentenced each of them to undergo RI for life for the offence under section 302 by 34, RI for 7 years for the offence under section 307 by 34, and both the sentences were directed to run concurrently. So far as the 27 of the Arms Act concerned, the appellant Vijay Kumar Rao and Jagdish Rao, they were the only two who were found guilty under 27, and they were sentenced to undergo RI for 5 years, which is to run concurrently along with the sentences awarded under section 302 by 307 by 34 of the Indian Penal Code. Stop. The prosecution case, as per the first information report lodged by PW1 MD Suresh Purthy before the IOTA के जो PW कहते हैं 18 पेज नंबर कहते हैं अच्छा before the inspector in charge town police station Sundargarh on 29/10/1996 is that PW1 was in the hospital on that day at about 2 p.m. in the Sundargarh District Headquarters Hospital, where he lodged the report before PW 18, and he stated therein that he was the driver of the vehicle of the deceased Amiya Das. On 27/10/1996 Sunday, in the morning, he brought the deceased and PW 8 Sarath Kumar Adia in the car from Rourkela to Sundargarh to Devasis Lodge, Sundargarh. And both the deceased and PW 8 stayed in room number 32.
Ohindra Kumar Adia. Ohindra Kumar Adia, son of Sarath Kumar.
Acha, my name is Anindra Kumar Adia, ANIDRA, देखिए लिख लो PW 18. अच्छा, both of them stayed in room number 32 अलग ना?
32 34 इटा रूम सी जे
तो लिखना में FIR लिखा है जी 32 रे समाने ରହିଲେ ବୋଲି
ଇଏ 35 ରେ ସେମାନେ
ହଁ।
32 ରେ ରହିଲେ।
କିନ୍ତୁ ସାର୍
they had come in connection with a murder case to Sundargarh Fort on 28/8/1996. PW1 took both of them to Sundargarh Court, and after the court work was finished, he brought them back to Devasi's Lodge. And on 29/10/1996, again he took them to Sundargarh Fort at about 10 a.m. and about to 12 noon, they returned to the lodge. At about 1 p.m., the deceased decided to return to Rourkela, and accordingly, PW1 brought the luggage from the room and loaded the same in the car and sat in the driver's seat. Stop. At first, PW8 came and sat in the rear seat.
Left side of the rear seat.
Left side of the rear seat. And 5 to 7 minutes thereafter, the deceased came and he was trying to sit
to the right side
to
of
the
rear seat.
to the right side of the rear seat, and at that point of time, someone suddenly fired gunshot at his right side chest, and the deceased shouted, shouting that inverted comma bhitar, "You killed my father, Ananta Raut, so also my brother, and you you acquitted you played a role for them. You played a role in the acquittal,
In acquitting the
in
culprits.
acquitting the culprits in that case,
I will not spare you.
and I will not spare you. And
I am his son.
and I am his son, Vijay Rao, and I will not spare you. Inverted commas. Hearing such threatening words, comma, no. After such threatening word, they again came, the culprits came to assault the deceased. And when PW1 got down from the car and came to the rescue of the deceased and caught hold of the appellant Vijay Rao from his back, comma, 3 other culprits who were there with appellant Vijay Rao. Out of the 3 culprits, who were there with appellant Vijay Rao, comma, one of them tried to tried to kill the PW1 and accordingly and assaulted PW1 on his head by means of a sharp cutting weapon. At that time, the deceased was shouting, inverted comma bhitare, Vijay Raut shot me and I will die. And please save me, inverted comma ends. When the persons of the locality rushed near the car. The culprits fled away, and the culprits had come in a car bearing registration number ORE 510, and the driver was
Absent in his seat.
absent in that car, and he had left seeing the incident. He had left the car seeing the incident, for which the culprits, finding no other way out, ran in the Raurkela road. The people congregated at the spot, and someone in his car took the deceased as well as the informant to the hospital. But by the time they reached at the hospital, the deceased had already died, and there was bleeding injury from his chest and from the back. It is further stated in the first information report that in connection with the murder case of the father of appellant Vijay Raut, there was hostility between the parties, and for that the incident took place. The dead body of the deceased was lying in the veranda of the hospital. It is stated that the 4 persons participated in the crime, and one of them is appellant Vijay Raut. On the basis of the oral report submitted by PW1, PW18 reduced the same into writing and sent the same to the police station for its registration, and accordingly Sundargarh Town PS case number 120 dated 29/10/1996 was registered under section 302, 307 by 34 of the Indian Penal Code and section 25 and 27 of the Arms Act against against the appellant Vijay Raut and three others. Stop. So this PW18 was not the IAC. PW18 was the
OIC.
officer in charge.
Yes.
No, officer in charge of Koida police station, but at that point of time, he was the sub-inspector police attached to town police station. The inspector in charge of town police station Sundargarh directed PW18 to continue the investigation after registration of the FIR, And PW 18 then proceeded to the spot for apprehending the appellants, directing the constable to guard the dead body of the deceased Ameya Das. Four accused persons were apprehended by public
See it.
and at different parts of the jungle at about 2:45 p.m. on that day, and accordingly PW 18 apprehended them and brought them to the hospital, where he held inquest over the dead body and prepared inquest report exhibit 3. He then dispatched the dead body of the deceased for post-mortem examination, examined the witnesses, including PW1, the informant who was undergoing treatment in the hospital. The statement of the appellant Vijay Kumar Raut was recorded under Section 27 of the Evidence Act. So also the other appellants. Stop. As per the statement of appellant Vijay Raut, one pistol bracket country made was seized from Tubolaya jungle containing empty cartridge in its barrel. One country-made 6-chamber revolver containing empty cartridge and 2 numbers of live cartridge. One live cartridge, another live cartridge were also seized as per seizure list, exhibit 23/1. से जो पिस्तल टा लिखिलो सेट लिख दियो MO2 और रिवॉल्वर टा होची MO नहीं पिस्तल टा होची MO3 और रिवॉल्वर टा होची MO2. On the basis of the statement of appellant A. Jagdishwar Rao, one country-made pistol, white wooden reef containing one live cartridge was recovered from inside the bush. The pistol top bracket like the MO4. As per seizure list, exhibit 24. Similarly, on the basis of the statement of appellant Jogeshwar Sunna, and at his instance, statement and at his instance, one plastic yellow handle barber razor, one spring knife with handle was seized from inside the bush. Razor टा होची MO5 ଆଉ spring knife होची MO6. As per seizure list, exhibit 25/1. Stop. At the instance of the appellant Satyajit Mahapatra, and at his instance, on being laid by him, one iron bhujali fitted with wooden handle was seized from inside the bush on the northern side of the road leading towards Raurkela. ये जो भुजालीटा कर दिया तो MO1 as per seizure list exhibit 26/1. The IO also seized the ambassador car bearing registration number ORE 510 in front of Devasi's Lodge as per seizure list exhibit 4.
Other ambassador.
On 29/10/1996, he sent the appellants for medical examination. Appellants like them Vijay Raut, A. Jagdishwar Rao, and Yogeshwar Suna. And he also seized another ambassador car bearing OR 05A 1867 at the police station, as that was the car in which the deceased had traveled. The deceased was traveling, as per seizure list exhibit 6/1. The IO sought requisition of the an officer from DFSL Raurkela to come to the police station to examine the scientific officer, to examine the seized car, the spot, and the weapon of offense. And he seized one bullet after the constable was produced the same from the doctor who conducted post-mortem examination as per seizure list exhibit 7/2, along with the wearing apparels of the deceased. The appellants were forwarded to court on 30/10/1996. On 31/10/1996, a prayer was made by the IO to the SDGM Sundargarh to conduct TI parade in respect of the accused persons. The register of the customer's entry and exit of Devasi's Lodge was seized as per seizure list exhibit 5. The seized Bhujali was sent to the doctor for examination and opinion, and the IO received the injury reports of the accused persons who were sent for medical examination. he sent the seized articles to RFSL Sambalpur through the Lieutenant SDGM Sundargarh for their examination. And received the C report exhibit 32. He released the seized vehicle in the Jima of one Surendra Das, received the PM report. Made a query to the doctor regarding possibility of the injury by bullet shot. Noticed on the deceased. He also released the vehicle ORE 510 in the Jima of Virsa Oram, the driver. Released the register of the Devasis Lodge under Jimanama of the manager of the lodge. He received the sanction order of the district magistrate to prosecute the accused persons under the Arms Act, and under completion of investigation, charge sheet was submitted against the appellants on 24/1/1997. Stop. After submission of charge sheet, the case was committed to the Court of Session, where the London Trial Court framed the charges as aforesaid. The appellants denied the charges, pleaded not guilty, and claimed to be tried. Accordingly, the sessions trial procedure was resorted to establish the guilt. In order to prove its case, the prosecution examined 18 witnesses. The prosecution also exhibited 39 documents, 9 material objects were also proved. Stop. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that the deceased has died of homicidal death, and considering the evidence of PW1, the eyewitness to the occurrence, so also PW8, and the identification made by PW1 in the TI parade, which was conducted by PW10, and the leading to discovery of the weapons of offenses. The London Trial Court found the appellants guilty under the offenses under section 302/34 and 307/34. The London Trial Court also found the appellant Vijay Kumar Rao and A. Jagdishwar Rao guilty under section 27 of the Arms Act. Mr. Akash Bhuiya, Land Counsel, appearing for the appellants in both the appeal, submit that so far as the appellant Satyajit Mahapatra in criminal appeal number 252 of 1998 is concerned, there is absolutely no material against him relating to his involvement in the crime. Neither he has been named in the first information report as an accused, nor he has been identified in the test identification parade, nor any of the two eyewitnesses have uttered their name or identified them in court. The only material available on record against the appellant is that at his instance, a bhujali was recovered by the IO bracketry PW18, which on chemical examination found to have contained human blood, but the grouping could not be ascertained as it has deteriorated, and there was no link was established between the seizure of bhujali with the crime, and therefore the conviction of Satyajit Mahapatra is not sustainable in the eye of law. The Land Council further argued that so far as appellant Vijay Kumar Raut is concerned, the London trial court has mainly relied upon the evidence of PW1, but the specific defense plea is that the said appellant was shown to the PW1 before TI parade, and therefore the test identification parade conducted by PW10 lost all its sanctity, and the London trial court should not have relied upon the same. The Land Council further submit that it is a fit case where benefit of doubt should be extended in favor of the appellants. Stop. Mr. Sarat Chandra Pradhan, London Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that not only the name of Vijay Kumar Raut finds place in the first information report, as the deceased uttered his name to be his assailant, which can be used as dying declaration, but also he was identified in the test identification parade and also in court by PW1. And the link of link of Satyajit Mahapatra with the crime has been established through the recovery of the bhujali at his instance, which was used in the crime, and therefore no interference with the impugned judgment is sought for. Adverting to the contention raised by the who is an injured witness for the PW1. Adverting to the contention raised by the Land Council for the respective parties, let us first examine the evidence on record as to how far the prosecution has successfully established that the deceased so-and-so has met a homicidal death. PW12 is the doctor who conducted post-mortem examination over the dead body of the deceased in District Headquarters Hospital on 29/10/1996, and he has noticed the following external injury. Quote kar dega. He has also stated the cause of death likely and time since death so and so likely. He has proved the post-mortem report as Exhibit 14. The IO has also made a query to the doctor regarding possibility of the injuries by the bullet, and the doctor has opined that the injuries are possible by the bullet, and the query report has been proved as Exhibit 15/1. Nothing has been brought out in the cross-examination to demolish the evidence of the doctor. In fact, the learned counsel for the appellants has not challenged the findings arrived at by the Dr. PW 12 in his PM report
With regard to the cause of death.
with regard to the cause of death. In view of the postmortem report, inquest report, and the postmortem, the evidence of the doctor, we are of the view that the learned trial court has rightly came to the conclusion that the deceased met with a homicidal death. Out of the two eyewitnesses, though PW 8 has stated about the occurrence, but he has stated that he did not know any of the accused persons. He has not even participated in the test identification parade, and the prosecution has offered no explanation as to why he was not taken as an identifying witness to identify the suspects. Therefore, from his evidence, though it is proved that an occurrence has taken place on 29/10/1996 at about 1 p.m. In front of so and so, say, lodge, Devasis lodge, and the deceased sustained firearm injury, and so also the PW1 sustained injuries on his person by a sharp cutting weapon, but the identity of the culprits has not been established from his evidence. Coming to the evidence of PW1, he has stated that in his evidence that he had taken the deceased and PW8 in a car to Devasis Lodge, and then from Devasis Lodge to the court premises, and he was staying in room number 35 of the Devasis Lodge, and on the date of occurrence, he was sitting in the driver's seat inside the car, and PW8 was sitting on the rear seat on the left side, and deceased came from the lodge to the left side of the car, and when PW8 told him to sit in the right side, the deceased was going to sit on the right side, and at that point of time, somebody fired at the chest of the deceased, and he found that the appellant Bijay Raut was standing. Bijay Raut fired at the chest of the deceased by a revolver, and at this the deceased shouted, "Malo mate bonchao, Bijay Raut mate guli marila," and then the appellant Bijay Raut assaulted the deceased on his head by the revolver from the left side. He further stated that when he caught hold of appellant Bijay Raut, the appellant Jagdishwar Rao dealt Bhujali blow on his head, and when at that point of time other persons came running to the scene of occurrence, on seeing them, the accused persons left the place and went near the car. Stop. PW1 further stated that the deceased told that, sorry, appellant Vijay Rao told, inverted comma ଭିତରେ, ମୋ ବାପାକୁ ମାରିଥିଲ, ମୋର ଭାଇକୁ ମାରିଥିଲ, କୋର୍ଟରେ ମୁଦାଲା ମାନଙ୍କୁ ଖଲାସ କରିଦେଲ, ମୁଁ ତାର ପୁଅ ବିଜୟ ରାଉତ,
ମୁଁ
ତତେ ଛାଡ଼ିବି ନାହିଁ, inverted comma ends. ହେଲା? At that point of time, since the car in which the accused person had come was not there in the car and he had gone somewhere, the accused persons fled away towards Raurkela. Ran away towards Raurkela. The PW1 further stated that a test identification parade was conducted in which he identified the appellant Vijay Rao, also appellant Jagdish Rao. Stop. So far as appellant Satyajit Mahapatra is concerned, the evidence of PW1 is completely silent against him. Stop. Neither he has stated anything against the Satyajit Mahapatra in the first information report, but also in the evidence. Stop. The PW1 was examined by the doctor PW11 who has noticed such and such injury, one incised wound of size so and so on the parietal bone, and the injury was grievous in nature, and it could have been possible by sharp cutting weapon. And the police sent the iron bhujali to the doctor and sought for his opinion regarding possibility of the injury sustained by PW1 with by such weapon, and PW11 has given his opinion in affirmative. Stop. Therefore, the presence of PW1 at the scene of occurrence cannot be doubted, and when neither of the two witnesses has implicated the appellant Satyajit Mahapatra in connection with the crime, and he has not been identified in the test identification parade, and the only evidence available against him is the seizure of bhujali at his instance as deposed to by the IO PW18, and from the said bhujali, the human blood was found with, but the group could not be ascertained due to deterioration. We are of the view that since the prosecution has failed to establish any link between the seizure of the bhujali with the crime in question, on that basis only the London trial court could not have convicted the appellants under section 302 by 307 or by 34 of the Indian Penal Code. Most peculiarly, the London trial court has stated that since se jo reasoning ta dechi kodi dechi jo ye pachuru dekhi par nathibo
62 page 63 page ର ଅଛି
page 63 o line ta kare
ମଝିରେ ଅଛି when the bhujali has been recovered at the
Acha,
instance
lekho.
of Satyajit Mahapatra.
Lion Grant has assigned while stated has
Well,
while
implicating
while arriving at the conclusion of the guilt against the appellant Satyajit Mahapatra, he has stated that since when the Bhujali has been recovered at the instance of Satyajit Mahapatra and the evidence of PW1 disclosed that he was assaulted with the Bhujali by accused Jagdishwar Rao, that can only be considered to be a mistake committed on confusion, and as such, no serious notice of the same can be given. And sure, we are not inclined to accept such reasoning assigned by the Lenin trial court, in as much as PW1 was from a close distance has seen his assailant,
yes.
and identified him to be the appellant Jagdishwar Rao, and he has also identified him in the TI parade and also in court during trial, and therefore the Lenin trial court seems to have made out a third case by convicting the appellant Satyajit Mahapatra. We are of the view that the conviction of the appellant Satyajit Mahapatra under section 302 by 34 and 307 by 34 of the Indian Penal Code, in absence of any cogent material on record, is not sustainable in the eye of law. Accordingly, he is acquitted of those charges. So far as the appellant Vijay Kumar Raut is concerned, apart from the fact that PW1 has named him in the FIR on the basis of the dying declaration made by the deceased, and also identified him in the test identification parade, also in court while deposing, and the is evidence that the bullet shot was fired by this appellant Vijay Kumar Rao is getting corroboration from the medical evidence adduced by the doctor PW12 who conducted post-mortem examination, and at his instance the revolver and the bullets were seized, and we are of the view that the Lenin trial court has rightly found him guilty under section 302 by 34 of the Indian Penal Code, so also 307 by 34 of the Indian Penal Code. The conviction of this appellant under section 27 of the Arms Act is also quite justified. Accordingly, so far as the appeal, criminal appeal number 252 of 1998 in relation with respect to appellant Satyajit Mahapatra is concerned, it is allowed. The so far as appellant Vijay Kumar Rao in so and so is concerned, it stands dismissed. It is stated that the appellant so and so is on bail. He shall surrender before the trial court within 15 days from today, failing which the Lenin trial court shall take steps for his arrest, serve out the remaining sentence. So I'll put a note of appreciation on Mr. Bhuiya and Mr. Pradhan. So anyone is ready for after lunch or will finalize?
item 19 paper utam
Mr. Das, you are ready? गुरुवार दिन करिवे एलसीआर कौन पेपर बुक तो नहीं जीवे आउ
एलसीआर ने
पेपर बुक नहीं जाओ पेपर बुक नहीं जाओ आउ जदी आपण जदी सीजीआर लिस्ट करिया जोडा एग्जिबिट है
नथियो जो
ताकू जोडा नथिबो जदी चाहिबे पेन ड्राइव रे नॉट द एलसीआर मिस्टर दास कौन कहले पहर दिन करिवे आपण
5 नंबर लॉन्च कर दे नेबे मु 4 नंबर सरला छोटे मैटर आइटम नंबर 5
के करियो नहीं हां ठीक
अच्छा
This is not system. This is the mention memo CRLA. Let the custody since 12 years.
tomorrow
Item 5.
May please losses. The only one active has preferred an appeal against life conviction by the additional district and sessions of the Rairanpur, Mayurbhanj. In this case, there is no eyewitness, and the name of the appellant also does not find in place of FIR, nor in his deposition. PW1 was deposed. There is no.
why don't you come to the judgment? Let us see. You read it a short one so we can finish it up.
Madam, in the page
8.
Madam?
Page 8 is the judgment.
Yes, my lord. The lordship turn to page 10.
No,
you start.
हमें जानी ना
Yeah,
अपन सिना
ma'am.
पढ़ी थी हमें जानी थी
The sole accused stands charged in 302 IPC. The prosecution case in short is that on the night of 30th August 97, between 3:30 AM to 4:30 AM, inside their common courtyard at Bohalda, assaulting head of the deceased, wife of the informant, by means of a chopper, accused committed her murder for prior dispute over the property. On written report of the informant, Bohalda PS case number 45 dated 31st August 97 was registered. Matter was investigated into after inquest over the dead body of the deceased. Same was subjected to medical examination from the spot, blood stain, earth sample, and earth of blood stain, school uniform of the son of the deceased, and on production by the accompanying police constable after postmortem examination, blood stain, sari, saya, blouse, rub, bangles, and sample of the blood of the deceased was seized. Accused while in police custody led to discovery of chopper, weapons of the offense, and his blood stain, lungi, banyan, and chodi kept submerged under water in a deckchi from his house, which were also seized. A hand watch, nail cutters, and sample blood of the deceased were collected and seized. Including articles were sent for chemical examination, and on completion of investigation, acquittal was charged under section 302 IPC. While denying the prosecution allegation in subject to PW3, the defense taken further plea that the informant takes a revenge on the accused himself, committed murder of the deceased, has rendered his case false. The point of the consideration are whether death of a human being whether death was caused by accused, whether the act by means of death caused was with intention to cause death. To establish this case, out of 16 CWS, prosecution has examined as many as 10 witnesses. Husband of the deceased is the informant. PW4 is the daughter of witness circumstances. PW6 is elder brother, is the post-occurrence witnesses. PW1 is the doctor who has conducted the postmortem examination. PW5, the local residents of a witness to the inquest. PW2, a police constable, and PW8, local residents are witness to seizure. PW7, a person of that area, and PW9 is the local residents are witness to leading of discovery. PW10 is the IO defense has chosen to examine none. At the beginning of the streamlined discussion and proper appreciation of the evidence, it would be useful to reduce the silent picture of the case in few lines. Accused is the elder brother of the informant, and PW6 is the eldest of three. All three brothers reside in one campus of their house surrounding on side of their two adjacent courtyard and house of the accused and the informant facing each other, joined by a common courtyard. Tulasi Chora, situated almost on the middle of the courtyard, few feet away from the spot towards the house of the informant. Boundary wall was beyond the barrier of the household of the brothers. Doors fitted on the entrance of the barrier from the household. The three brothers separate means. Thereafter, there is no eyewitness to the alleged murder, and prosecution has mainly depends on the evidence of the leading to discovery. Result the chemical examination of this seized exhibits and prior enmity between the parties. With these backgrounds, the evidence recorded to the stand. Death of the deceased, not open to dispute, appears to be homicidal when it is the evidence of the PW1 Assistant Surgeon, ST Hospital, Rairanpur, that on 31st August 97 at 1:45 p.m. the police requisition conducting postmortem examination on the dead body of the deceased. He found 6 incised wounds running parallel to each other, varying between 4.61 bone webs on the left partial bone and bruises over the eyelid to open the injury to the antemortem in nature. The death caused due to harmless and shock out of fracture of the skull bone and injury to the vital organ within 12 to 24 hours of his examination. By Exhibit 1, the postmortem examination report granted by this doctor on 9/9/97 examining produced proper opined possibility of the injury that as weapons by Exhibit 2 his opinion to the police query. It is the affair story that at about 1:30 night on 30th August 97, when the informant found his wife absent from his bed, he sent his daughter PW4 to find if the deceased had been to Latin. PW4 found the deceased to have gone to seize herself.
Ease herself.
The fact she reported to her father, the informant going to the deceased found her washing herself, but she not coming inside the house. So, inside the house, slept near Tulasi Chora in the courtyard, waiting to take bath on supply of water on the tap. Whereafter, the informant returned to his bed, and sometimes thereafter, hearing dropping sound of water from the tap, he going near to Tulasi Chora found the deceased lying dead in pool of blood little away from the Chora. After which, calling PW6, 4 and 6 to the spot, he reported the matter in writing at PS, figuring his accused and his wife on the assailant. The affair story has been quoted by PW3-4. Though PW6 has gone hostile to prosecution, still it is in his evidence that being called by informant PW3, reaching the spot at the fateful morning, he found deceased lying motionless on the courtyard. This commission of murder of deceased at the fateful hour at the spot has been admitted by the defense in way of suggestion to PW3. It is the evidence of PW10, the IO, that the accused, while police custody, giving information of concealment of the iron curtain chopper on the top of the almirah inside his kitchen, gave recovery of the chopper MO number 1, which is seized under seizure list Exhibit 6. It is his further evidence that accused also, while in such custody, giving information of the concealment of his lungi, banyan, and chori inside a dekchi, submerging those in water. Dekchi kept in inverted position inside his bathroom, give recovery of the lungi MO3, banyan lungi MO2, banyan MO3, and undergarments. The MO4 from there, which was seized under seizure list Exhibit 7, this evidence of the PW10 was received neck-to-neck corroboration from that the PW7 and 9, the two witnesses to alleged leading to discovery, who have read that their presence at the PS accused giving information of concealment of the koturi. The weapons of the offense inside the kitchen and his lungi, banyan, chori inside dekchi in his bathroom led them enter and gave recovery of that curtain MO number 1 from the top of the almirah of his kitchen, which police seized under seizure list Exhibit 6, containing their signature SW Exhibit S1 and S2, 6261, and gave recovery of his lungi MO2, banyan MO3, and chori MO4 from inside the dekchi kept inverted into the bathroom, which police seized under seizure list Exhibit 7, containing their signature, while Exhibit 7.1 and 7.2. Learned Defense Counsel urged to give no credit to the evidence of PW 7 and 9, submitting that they are the choose one when PW 7 is the residence of 4 miles away from police station and PW 9 is the stock witness of the police. On their availability at PS, it is evidence of PW 10 that after arresting the accused and bringing him to PS, he, anticipating giving out of his clue by the accused, sent police constable to get 2 independent witnesses who called PW 7 and 9. Of course, when PW 9 was supported with the evidence and PW 10 that being called upon by the police constable, he came to the police station. It is the evidence of PW 7 that in connection with the seizure of documents of the vehicle of his nephew, he had been to PS and had denied to give statement before the IO that he was called to the PS by the police. In fact, which has been negated by IO, PW 10 maybe this little discrepancy hitchcraft in the evidence of PW 7 when he has been brought to witness box about 11 months after alleged leading to discovery, and for that it is taken to be not sufficient enough to discredit the testimony not structured otherwise. So it is well made out from the evidence of PW 7, 9, and 10 and Exhibit 6 and 7 that the accused, while in police custody, giving information of concealment of curtain koturi chopper MO number 1, gave recovery of his same from the top of almirah inside the kitchen, and in such condition, giving information of concealment of his lungi MO2, banyan MO3, and underwear in MO4. Submerged those were water in the dekchi, gave recovery to this from his bathroom, and recovered MO was seized under seizure list Exhibit 6 and recovered MO 2, 3, and 4 were seized under exit list of Exhibit 7. This reflected in Exhibit 6 that the recovered curtain was the weapon of the offense, appearing to have committed such strain of blood and Exhibit 7 that recovered wearing apparel were put on by the accused at the time alleged murder. And even if PWC 7, 8, 9, and 10 have not read MO number 1 to be weapon of offense and MO 2, 3, 4 to be the wearing apparel put on by the accused at the time of alleged murder, judicial notice of the same is to be taken. Learned Defense Counsel also to discard the evidence of leading to discovery, submitting that accused was not the exclusive owner and user of the bathroom from where recovery has been made as alleged. Of course, it is the evidence of the informant, PW3, that they were possessing living rooms separately and they were using common bathroom, latrine and bathroom, but the spot map, Exhibit 9, reveals that both the family had separate bathroom. And it is the evidence of PW4 that the night deceased was passing night soil on the drain between the house of the accused and PW6. As such, it is found that the relevant time both the family were not in the use of a common bathroom and latrine. Moreover, when time gap was the alleged incident and the alleged recovery is so short, there is no other evidence as to how recovered wearing apparel from the accused would come to the place of recovery. There is no scope to conceive incorporation of the recovered articles at the recovered place by any other person. Exhibit 11 is the chemical examination report on chemical examination of the selected sample of blood of the accused. Same has been found in the human B group and of the same has been found human AB group and AB group of the human blood has been detected in the seizure sari, saya, blouse and bra of the deceased and seized banyan MO number 3 under wear MO 4 of the accused and human blood has been detected in the seizure lungi MO 2 of the accused. Of course, due to non-availability of the on-strength control in its grouping could not be met. As group of human blood is rare variety of the blood and tallying with the variety of blood deceased with the blood stain on the seized banyan and undergarments of the human strangeness of the prosecution case. Learned Defense Counsel, citing decision reported in 87 Supreme Court 1507, submitted that the detection of blood in seized wearing apparel on the accused is novel to prosecution. In citation, their lordship have held P. Penal Code 45 300 Evidence Act, Section 3, Murder, Circumstantial Evidence, Recovery of Blood Stain, clothes from accused, a report of this seriography that clothes were stained with human blood, but blood group could not be indicated, dimension of the blood stain, and clothes also not given in the report. Evidence of blood group is only consequence of connect blood stain with accused, no reliance could be placed on it. I am of the view that the cited principle has no application to the case in hand. Both the cases stands on different footing. In the cited case, when blood has not been indicated in case in hand, the same has been determined. As such, the contention of the Learned Defense Counsel is not tenable. What is the reason behind the alleged murder? It is the evidence of PW6 that informant and the accused were in dispute and quarreling, but not dragger's end, and were compromising and had constructed their common latrine while living separately mess. It is the unchallenged evidence of information that prior to this incident in the month of June, accused had broken one of his fingers of his hand, which matter compromised, and accused and his wife were quarreling with them and told that one of his family members was to be murdered. Thereafter, partition could only materialize. This evidence spells out the reason behind the alleged murder. As a routine of matter, the chapter of investigation may be reduced in the line or two, which in the evidence of PW 10, the IO that on 31st August 97 at 6 a.m. on receipt of the written report, Exhibit 4 from the informant, he treated the same as FIR, registered the Bahalda PS case number 45 dated 31/8/97, by his endorsement, that is Exhibit 4/2, due of formal FIR, Exhibit 4/2, took up investigation, visited the spot, prepared the spot map, Exhibit 9, examined the informant and witnesses, held inquest report of the dead body of the deceased under inquest report, Exhibit 5, sent dead body for postmortem examination. From the spot, made seizure of blood stain, earth sample, earth blood stain, uniform consisting their half pant and half shirt, son of the deceased under seizure list, Exhibit 8, accused while police custody gave recovery MO1, which seized under seizure list Exhibit 6, and MO2, 3, 4, which was seized under seizure list Exhibit 7. After postmortem examination on production by the accompanying police constable, made seizure of blood stain, sari, saya, blouse, and bra, bankulas, and the collected sample blood of the deceased. Under seizure list Exhibit 3, also made seizure of the collected hand wash of the accused under seizure list Exhibit 10, subject to implement seizure articles to chemical examination through court. On completion of investigation, placed the charge sheet against the accused. His evidence on the inquest has been verified by PW5, who has admitted his signature by the Exhibit 5.1 on the inquest report. On seizure from the spot, PW8, who has admitted his signature in Exhibit 8.1 on the seizure list, and seizure of wearing apparels, etc. The deceased under seizure list Exhibit 3 by the PW2, who has admitted his signature, Exhibit 3.1 on his seizure list. The learned defense counsel made at the last attempt out it of prosecution, submitting that there is a possibility of commission of alleged murder by way person entering into the courtyard or scene over the boundary wall of the less height, and when informant not suspected the accused to be the assailant, not naming him to PW6 soon after the detection of the alleged crime by him. In spite of his strenuous attempt, the learned defense counsel, it has not been brought to the evidence there was a scope for anyone to enter into the courtyard that night, not naming the accused as assailant in the to PW6 by the informant is not raised out, when it is the evidence of PW6 that on the morning the informant PW3 called him and his house, saying that his wife was lying motionless on the courtyard, and at that moment to choose to informant was not probably sure of the death of the deceased. As such, this contention of learned counsel defense is not tenable. To summarize the discussion, it is to be recorded that on the night on 30th August 97, in the common courtyard, at the time of accused and informant, and little away from Tulasi Chaura of that courtyard towards the house of the accused, the deceased was found lying dead. The accused led to discovery of MO1, the weapon of the offense, and MO2, 3, 4, the wearing apples. He had put on his time of the murder from the house. Examining MO1, the doctor of PW1 opined possibility of injury of the deceased of that weapon. On chemical examination, the blood found in recovered banyan and undergarments of the accused tallied with the sample of blood of the deceased, and blood found in the seized wearing apparels of the deceased and over partition of property. There was dispute and quarrel between the informant and the accused and his wife, and the latter had expressed murder of the members of the family of the informant as to the only solution to pave way to the partition. And all these facts led to irresistible conclusion that the accused and none else is the author of the crime. It may amount to an omission if it is not mentioned that no attempt has been made by the defense to settlement. It is plea that to take revenge against the accused, the informant has in himself killed his wife, and by no stretch of imagination, seizing the blood-stained school uniform and of Monty, the son of the informant, lying by the inside of the dead body at the spot. It is the use of the suggestion, maybe several assaults on the head while the deceased was fast asleep, left no occasion to raise shot by her on receipt of assault. In this premises, it is held that prosecution has well succeeded in bringing home its charge against the accused beyond all reasonable doubts, and accordingly, the accused is found guilty under section 302 and convicted. The seizure articles will be destroyed after appeal if no appeal is preferred and selected ethically. Pronounced report in open court. Hard sentence, learning counsel or the partial lenient sentence in consideration of the fact and circumstances of the case, submission of learning counsel convict the sentence to undergo RIA for life. This is the case number. Let's see. The first FIR. FIR, there is no whisper. And in August, it is a night at 1 p.m. The deceased slept in a open air space at night, and he got information that when tap was water comes from tap, that is at 5 a.m. He came to know that water is coming. Then he arose and went to see that his wife was lying there, and he asked, shouted, his doctor came. At that time also she said that your elder father died or had been killed by his elder father. And he also morning informed his elder brother, to whom he has also not said. And there is a common bathroom. That is, they are using common bathroom. And also, your lordship, can I go through the affair, my lord?
Yes, please.
ନିବେଦ୍ୟର ଏଇଟି ଅଦ୍ୟ 31/8/97 6ଟା ସମୟରେ ଥାନାରେ ଉପସ୍ଥିତ ହୋଇ ଲିଖିତ ଅଭିଯୋଗ କରୁଛି। ଗତକାଲି 30/8/97 ରାତିରେ ଆମ୍ବେ ସ୍ୱାମୀ
Informant ହେଲା PW3.
yes
Yes.
PW3
ପଢନ୍ତୁ
PW3 ଆଇ ଗୋ
ପଢନ୍ତୁ ଆପଣ ନାଇଁ ଏଫଆଇଆର ଟା ପଢନ୍ତୁ ଏଟା କିଏ
ନିବେଦ୍ୟ ଦେଖିଲି ଯେ ମୋର ସ୍ତ୍ରୀ ବିଛଣାରେ ନାହାନ୍ତି। ଦେଖି ମୁଁ ମୋର ବଡ ଝିଅ କୁମାରୀ ମଧୁମିତା ସାହୁକୁ ଉଠାଇ ଯୋଉ ମା ପାଇଖାନା ଯାଇଛି କି ନାହିଁ ଦେଖିବା ପାଇଁ କହିବାରୁ ସେ ଦେଖି ଆସି ତା ମା ଝାଡା ଯାଇଥିବା କହିଲା। ତାପରେ କିଛି ସମୟ ବିତିଯିବା ପରେ ସେ ନ ଆସିବାରୁ ମୁଁ ନିଜେ ଯାଇ ତାକୁ ଡାକିଲି। ସେ ସମୟରେ ସେ ଗୋଡ ହାତ ଧୁଆଧୁଇ କରୁଥିଲେ। ମୋର ଡାକ ଶୁଣି ସେ ମୋ ପାଖକୁ ଆସିଲେ। ମୁଁ ପାଇଖାନା ଯାଇଥିଲି, ପାଣି ଆସିଲେ ମୁଁ ଗାଧୋଇ ଘର ଭିତରକୁ ଯିବି, ତୁମେ ଶୋଇଯାଅ। ତାଙ୍କ କଥା ଶୁଣି ମୁଁ କହିଲି ପାଣି ଆସୁ ଆସୁ 3:30 ହେବ, ବର୍ତ୍ତମାନ ସମୟ ହୋଇନାହିଁ, ମୁଁ ହାওଲାରୁ ପାଣି ଦେଇ ଦଉଛି, ତୁମେ ଗାଧୋଇ ପଡ। କିନ୍ତୁ ସେ ମନା କଲେ। ମୁଁ ଏହି ତୁଳସୀ ଗଛ ଶୋଇଛି ଓ ବାଥରେ ପାଣି ଆସିଲେ ଟ୍ୟାପରେ ପାଣି ଆସିଲେ ଗାଧୋଇ ପଡି ଘରକୁ ଯିବି, ତୁମେ ଶୋଇପଡ। ଏହା କହି ସେ ବାହାରେ ଶୋଇଲେ। ମୁଁ ଘର ଭିତରେ ଯାଇ ଶୋଇଲି। ପାଇପରେ ପାଣି ପଡିବା ଶବ୍ଦ ଶୁଣି ଯାଇ ଦେଖିଲି ମୋର ସ୍ତ୍ରୀ ଯେଉଁଠି ଶୋଇଥିଲେ ସେଠି ନ ଶୋଇ ଅନ୍ୟ ଜାଗାରେ ଶୋଇଥିବା ଜାଗାରୁ 2-3 ହାତ ଦୂରରେ ଶୋଇଛନ୍ତି। ପାଖକୁ ଯାଇକି ଦେଖିଲି ସେ ଠାରେ ରକ୍ତ ପଡିଅଛି ଏବଂ ତାଙ୍କୁ ଡାକିବାରୁ ଶୁଣୁନାହାନ୍ତି। ମାଆକୁ କିଏ ମାରିଦେଲା ବୋଲି ପାଟି କଲାରୁ ମୋର ବଡ ଝିଅ ପାଖକୁ ଦୌଡ଼ି ଆସିଲା ଏବଂ ତା ମାଆକୁ ହଲାଇ ଡାକିଲା। ସେ ନ ହଲିବାରୁ ଜାଣିଲି ତାକୁ କିଏ ମାରି ଦେଇଛି। ଦେଇଛି। ଏହା ଦେଖି ମୋ ବଡ଼ ଭାଇ ମଦନ ଲାଲ ସାହୁଙ୍କୁ ଯାଇ ଡାକିଲି ଏବଂ ଅନ୍ୟ ଲୋକମାନଙ୍କୁ ଡାକିଲି। ପ୍ରକାଶ ସାହୁକି ଏହି ଟିକେ ପ୍ରକାଶ ସାହୁକି ମୋର ବଡ଼ ଭାଇ ଶ୍ରୀ କିଶନ ଲାଲ ସାହୁ ଡାକିଲି ଆଣ୍ଡ ତାଙ୍କ ସ୍ତ୍ରୀଙ୍କ ସହିତ ଜମି ଜାଗା ନେଇ ଗଣ୍ଡଗୋଳ ଲାଗି ରହିଛି ଏବଂ ସେ ବିଷୟରେ କୋର୍ଟରେ କେସ୍ ଲାଗିଅଛି। ଏହି କାରଣରୁ ଗତ ଜୁନ 97 ମାସରେ ମୋର ବଡ଼ ଭାଇ କିଶନ ଲାଲ ମୋର ବାଁ ହାଡ଼ରେ ଆଙ୍ଗୁଠି ମୋଡ଼ି ଭାଙ୍ଗିଦେଲେ, କିନ୍ତୁ ଘର ଭିତରେ ଆପୋଷ ସମାଧାନ ହୋଇଥିଲା। ତାପରେ ମଧ୍ୟ ଗତ ସପ୍ତାହରେ ପାଣି ଏବଂ ପାଇଖାନା ସକାଶେ ସେ ମୋ ସହିତ କଳି କଜିଆ କରୁଥିଲେ ଏବଂ ମୋ ତଣ୍ଟିରେ ଟିପ ମାରି କହିଲେ ପ୍ରାୟ ସବୁ ସମୟରେ ସେ ଏବଂ ତାଙ୍କ ସ୍ତ୍ରୀ ସୁଷମା ସାହୁ କହୁଥିଲେ ଏହି ଘରୁ ଗୋଟାଏ ଲୋକ ନ ପାଇଲା ପର୍ଯ୍ୟନ୍ତ ଘର ଭାଗ ବଣ୍ଟନ ହୋଇପାରିବ ନାହିଁ ଏବଂ ଏମାନଙ୍କୁ ମର୍ଡର କଲେ ଯାଇ ଶାନ୍ତି ମିଳିବ। ଏଣୁ ମୋର ବିଶ୍ୱାସ ଯେ ଶୋଇଥିବା ଅବସ୍ଥାରେ ମୋ ସ୍ତ୍ରୀକୁ
କିଶନ ଲାଲ ସାହୁ
ବଡ଼
ଏବଂ ତାଙ୍କ ସ୍ତ୍ରୀ
ସୁଷମା କୌଣସି ଅସ୍ତ୍ରରେ ଏବଂ
ମୁଣ୍ଡରେ ବାରମ୍ବାର ଆଘାତ କଲେ।
ଜୀବନେ ମାରିଛନ୍ତି। You come to the evidence of PW3.
My lord.
Informant, right?
Informant. Accused is my brother. This is Nirmal is my wife. On the night 30th August 97, she was murdered. On that night, at about 1:30 o'clock, when I found my wife not on her bed, I asked my daughter, Madhusuta Sahu, alias Bunty, to find out if her mother had been to Latin. She verified and told that her mother had been to Latin. Then, after some time, went to call her and told to come afterwards, after getting her bath. So I returned back and slept in the house when she slept near Tulasi Chora, outing town supply water. Hearing dropping sound of the water from the tap, I got up and going out, found the deceased 2 to 3 feet away from the place where she was sleeping. When she did not respond to my call, I went near her and found her in a pool of blood. So I raced about at Madhusuta.
I raised south.
I raced out at Madhusuta, shouting her mother was dead, was murdered. Thereafter, I called my elder brother, Madan Lal, and others. I had landed dispute with accused over which litigations and different courts. Prior to the incident, in month of June, accused had broken one of my fingers of my hand, and the matter was compromised. Accused and his wife were always quarreling with us and had told that one of my family members was to be murdered. Whereafter, partition could only be materialized. The accused and his wife, with some weapons, often assailing head of the deceased repeatedly, and caused murder. I reported this incident in writing at police station, written by me, and written report exhibit 4/1, my signature. In my presence, accused, while in police custody, giving information of concealment of the weapons and offense and his washed clothing, gave recovery from the same. My house and that of the accused intervened by a courtyard, and the house of Madan Lal was beyond the adjacent courtyard. Both the courtyards were surrounded by the house of all brothers, cross-examiners. After calling Madan Lal and showing him the spot, I went to PS and reported the matter to police. I scribed the affair at the police station. The boundary wall of our bari was about 10 feet in height. The entrance door of outside to the bari, through that all the being kept closed always. The common entrance of the door, common entrance of door from the road to our house were also being kept closed all the times. Those soft rooms we brothers used to go out our house. Madhusmita at that night had slept in another room and being asked by me, called her mother near the Latin. I myself and the accused had a common water tap. I had not dissuaded the deceased to sleep near the Tulasi Chowra. She slept there, her dead head facing north. She had slept on the ground. At about 5 o'clock morning, I got up hearing from sound of the water from the tap and came out. I found deceased then lying in a pool of blood. Blood lying scattered in the major portion of his coat, wearing sari, and deceased were stained with blood. Also, wearing apparels of my children lying there were stained with blood. I myself and the accused had constructed our common latrine. The children of the accused used to see TV, so in the TV purchased by me, bloodstained full uniform shirt and pant of my son Monty were seized by police. At the first sight of the dead body of my wife, I raised suspicions on the accused and his wife. I have not called the accused. I cannot say if she had come to a dead body or not. Tulasi Chowra was about 8 feet from the house of the accused, was almost equal distance from Chowra. I had not asked the deceased to sleep on the veranda instead of near Tulasi Chowra. I had not verified if the front entrance door and back entrance door were open or closed, as those always remain closed. At the PS, accused gave information of concealment. The police did not suspect me to be a murderer. I have not examined by the police. We had not participated. We had not partitioned our property through, though we are possessing our living room separately with common latrine and the bathroom.
PW4 has just stated about that last time she went and called her mother,
Yes.
and mother told me to return after easing herself. Then she came back and told the father and slept.
Okay.
And the next day she saw the dead body. 5 is the impressed witness. 6 is so I'm sure about 1 year I know with report to myself. Not supported because in some case of
6 also.
who are 1 and 2?
Well, one police.
One is
Ayo.
doctor.
Doctor. Sorry, doctor. One is the doctor. Who is the constable who are in the death, postmortem against body?
He has escorted the dead body for postmortem examination or what?
No,
Or produce the अच्छा जो साड़ी साया ब्लाउज
की production of
जोड़ा प्रोड्यूस कला
मान।
डिसीज जोड़ा कायो सीज कला
man.
बाकी रहला 6 नंबर साकी कौन ओका कला कुछ कर देन ओके 7 कौन कहला
Sir, the seizure my lord, your lordship, that on 31st August 97 at about 11, both of is my presence, in my presence, and that of Samalal and PW3 informed.
Leading witness
बाहर नहीं बाहर दा छान थानरन
My lord.
बाहर दा थानरे
inside his kitchen.
accused giving information to a kid
हाँ,
so and so the
that
weapon of
witness
the kitchen अच्छा
gave recovery of the kotua from the top of the almirah at the kitchen of the kitchen, which
Yeah.
7 and 9 both are free.
Both.
7 and 9 leading to this.
My lord.
Check lungi or weapon.
Inside that check.
This is the brother, another brother, there is a three brother.
Yeah, there କିଛି blood ମିଳିଲାନି ଚପରରୁ.
No.
That is the C report, page 52. ବାକି ଆର
All are the blood AB positive.
Mm-hmm.
Daniel এবং Sadi, all the blood group is a human AB positive. The blood matching.
but
Except Chopper,
Chopper, no blood.
because of their keeping
where
the
these articles
dick
were
teeth.
kept, where these articles were kept after seizure, where is the material about safe custody? You have not stated anything this IO. And it was produced about a month after. You see that MO1 was seized as per seizure list exhibit 6, na?
Ma'am.
In which no blood was found.
Yes.
बाकी रहला ये जो जहाँ ब्लड आछी से जो
Lungi.
लुंगी बैनियन अंडरवेयर एथरे आछी नुए
Yes.
सेगुड़ा को जबत हला केबे एग्जिबिट 7 रे बोले exhibit 7 I think it is dated 31/8/2007.
Yes.
30 ना 30 नहीं exhibit 7 डॉलर को ना हाँ এটা 31/8/1997 from the bathroom of the accused
My lord.
those were seized तार निजर चेक लुंगी ଆଉ ଗୋଟେ ଫୁଲ ଚଡି ରୂପା ଆଉ ଗୋଟେ ହାତକଟା ଗଞ୍ଜି ଛୋଟ ଆଲୁମିନିୟମ ଦେଖିଛି ଯୋଉଥିରେ କି ଏଇ ଯୋଉ
ଭର୍ତ୍ତି
ତିନିଟା ଯାକ ଲୁଗା
ରହିଥିଲା।
ରହିକିନି ପାଣିରେ ଭିଜା
ପାଣିରେ ଭିଜା
ହେଇଥାଏ।
ହେଇଥିଲା। My lord. But the informant has not said that lungi, chodi, ganji belongs to his brother.
Just a minute. IO has not stated anything about safe custody. Total silent. खाली कहला जबत करदेली
My lord.
तापरे जबत करिकिनी ताकू मु पठेई देली एसएफएसएल
SFP.
किछि कहनी माने फॉरवर्डिंग रिपोर्ट टा देखिए पेज नंबर 50 रे कौनसी आर्टिकल जेतेबेले प्रोड्यूस हेची सेडाको सील्ड कंडीशन ने थिला बेली भी लिखा है खाली जस्ट सिंपल ये एटा जब प्रोड्यूस होइछि आपनकर 27/9/1997 ना साक्षी कौची आपनकर आईओ जबत होला पर को टाइप रो कंडीशन रे रहिला जब गुड़ाक 31/8 तापरे प्राय मासे परे कोर्ट रे प्रोड्यूस होइछि सेति मध्ये सील्ड कंडीशन नाही 31/27/1997 लास्ट सीन नाही एक्स्ट्रा जुडिशियल कन्फेशन नाही आउ से गोटे कौन कड़ी तांको भितर हेइतला दी जन
खाली उठे
मोटी माने से जो कोन
प्रीवियस एनमिटी रे जो
कॉमन टॉयलेट गोटे से माने करिथिले बोधे दी जन जाक वाटर टैप दी जन जा पैसा खर्च करी सेई थ्रु बोधे कोन किछि विवाद हेइथिला एटा PW3 को एविडेंस रो आछि
Schedule 4 evidence the doctor of the disease.
PW4 तो कहला मते बापा पठेला मु जाई देखिली बो कहला तू जा मु ये करी जीबी इस करला परे मु जीबी बोली से आसी मु आसीकिन बापा को कहली मु सोई पई तापर उठिला लो देखला लो बोर डेड बॉडी केमती आपण एसु कोन चेन कंप्लीट केमती करैबे अच्छा से घर जो हेछि जोठी अगणा रे जो पड़ीथिला सेटा जा जणा पुरची गोटे 10 फुट रो
कॉमन कोठा
हां कॉमन कोटियाट तार बाउंड्री टा होछि 10 फीट बोधे जो वाल टा अछि एटा क्लियर कहछि एविडेंस नो
हां 10 फीट
हाँ the boundary wall of cross paragraph 8 was about 10 feet in height. Entrance door from outside to the throat was been kept closed always. The common entrance door from the road of our house was also being closed all the day. The soft rooms of
two brothers
of the wee brothers. So दी भाई थिले हो हाँ
used to go out our
Schedule 6 जे आउडे भाई से बाहर
ବାହାରେ ରହୁଛି
ना ना ये एठी घटना बड़े दी भाई
भाई गोटे
गोटे भाई होची PW3 आरो भाई टा अक्यूज हो
and there you living separately but use common only.
हाँ सेही पूरा कॉमन टा ये एकुटिया माने खर्च करथिले बोले सेही एविडेंस आछि ना का एकाठी गोटे कॉमन लैट्रिन ना कॉमन सेटा बाथरूम कोन सेटा यूज कोर्स ना कॉमन
लाट्रिन এবং ডেড বডিটা কমন লাগে
डेड बॉडी टा सी
স্পট ম্যাপ রে দেখুন ডেড বডিটা অ্যাকুইট র ঘরর সামনে
कॉमन कोटिया टा तो
ना এই কোটিয়াটা কার এপট কোটিয়াটা আগোটে
কমন কোটা
এইটা এটা কার এটা তো ইয়ার কো দেখলেন ডেড বডিটা তো এইটা হচ্ছে কমন
हाँ एटा कॉमन आरो
so more closer to that side only এটা তো স্টোরাটা বলে
तुलसी चोरेट दिखी
हाँ
ये
so it is more towards that side
accused এটা হচ্ছে বেডরুম অফ দি অ্যাকিউজড এন্ড হিজ ফ্যামিলি মেম্বার্স
right
তারপরে ইয়ার হচ্ছে কোঠি বেডরুম অফ দি কমপ্লেনেন্ট তার
কর্নার রে যাই বেড কমপ্লেনেন্ট
কিচেন রুম ওপেন স্পেস রହୁଛି ବାରାଣ୍ଡା ରହୁଛି ଆଉ ଗୋଟେ ଲେନ୍ ରହିଛି ଗୋଟେ କୋଉଠି ଗୋଟେ ବାଟ ଆଧିର ଅଛି ସେ ଯୋଉ ୱାଲ ଚାରିପଟେ ଗୋଟେ ବାଟ ଯୋଉଟା କି ଏ ଦି ଜଣ ଭାଇ ଯାକ ୟୁଜ କରନ୍ତି
କମନ ଏଣ୍ଟ୍ରାନ୍ସ
ହଁ ଏଣ୍ଟ୍ରାନ୍ସ ସେ କହୁଛନ୍ତି କମନ ଏଣ୍ଟ୍ରାନ୍ସ ପାଚିରିଟା ହଉଛି 10 feet।
10 foot height।
ଏଇଠୁ ଗୋଟେ ପାଖରେ ଗୋଟେ କାହାର ଏଠୁ ବାରି ରହିଛି, ଏଇଟା ଗୋଟେ କାହାର ଗୋଟେ, ଏଇଟା ହାଉସ ଅଫ ଗୋଟେ କଣ ମଧୁଲାଲ ସାହୁ, ଏଇ ଯୋଉ ତଳେ ରହିଛି କଣ
ମଦନ ଲାଲ ସାର୍।
ମଦନ ଲାଲ ସାହୁ।
ମଦନଲାଲ ସେ ଆଉ ଜଣେ ଭାଇ
ହଁ।
ଆଉ ଗୋଟେ ଭାଇ P66।
ହୁଁ, ହୁଁ। ଏ ଯୋଉ ଏଭିଡେନ୍ସ ସମ ଅପ୍ କରିଛନ୍ତି ଯୋଉ ଇଏ ଆମର ଟ୍ରାଏଲ କୋର୍ଟ ଯୋଉ ସମରାଇଜ କରି ପାରାଗ୍ରାଫ 12 ନା, ଆଉ ଥରେ ପଳେଇ ଆସୁନାହାନ୍ତି ସେଠିକି ଦେଖୁନ। କମନ କୋର୍ଟ ୱାର୍ଡ ସେ କହୁଛନ୍ତି that is not disputed। accused of informant ଗୋଟେ କମନ କୋର୍ଟୟାର୍ଡ ଥିଲା little away।
Common courtyard is not disputed, and with regard to their
ଏ ଯୋଉ ତୁଳସୀ ଚଉରା ଥିଲା ଗଲା, deceased was found lying dead, ସେଟା ବି ମଧ୍ୟ not disputed। MO1 କଟାରୀ ବାହାରିଲା ଯୋଉଥିରୁ ବ୍ଲଡ ନାହିଁ। 2, 3, 4 ଏଇଗୁଡା କହୁଛି ୱେରିଂ ଆପେରାଲ୍ସ। ସୋ ଯୋଉଥିରେ କି ବ୍ଲଡ ଟା ମିଳିଲା, ଯୋଉଟା କି କନେକ୍ଟ କରୁଛି ମାନେ ଡିସିଜ୍ଡ ର ଯୋଉ ୱେରିଂ ଆପେରାଲ୍ସ ର ଯୋଉ ବ୍ଲଡ ତା ସାଙ୍ଗରେ ମ୍ୟାଚ୍ କରୁଛି। ହ୍ୟୁମାନ ବ୍ଲଡ ଅଫ AB ଗ୍ରୁପ ଏଠି ତ ହବ। ବାକି ଯୋଉ ଗଣ୍ଡଗୋଳଟା କଣ ଥିଲା ତାଙ୍କ ଭିତରେ,
blood group matching, previous quarrel between the parties,
and
And-
the postmortem report, the doctor report, that is the 2 injury in the brain.
eh?
postmortem
that
to
is the-
homicidal death
homicidal
dispute
also.
କରୁନାହାନ୍ତି।
That is not.
homicidal death
No, weapon of offense जोटा बाहरला leading to discovery, that is
that is no blood।
no blood.
Cross examination,
Iron
the
chopper।
IU,
এইଗୁଡାକ ଏଇ ଯୋଉ
Wearing
ତାର ଲୁଙ୍ଗିଟାରେ ନୋ ଓପିନିଅନ, ହ୍ୟୁମାନ ବ୍ଲଡରେ ନୋ ଓପିନିଅନ। ଏଇ ଯୋଉ ଏଇଟା ମିଳୁଛି ଆର ଯୋଉ ଅଣ୍ଡରୱେୟାର ଆଉ ଏଥିରେ ଏଇ ବ୍ଲଡ ଟା
AB
ରହିଛି, ଯୋଉଟା କି ଆ ଶାଢୀ ବ୍ଲାଉଜ ଇଏରେ ହ୍ୟୁମାନ ଏଇଗୁଡାକୁ ସେ କନେକ୍ଟ କରୁଛି।
P30 active statement ସେମାନେ ସବୁ କିଛି ତା ଦେହରେ ମଧ୍ୟ କିଛି
କହିନାହାନ୍ତି।
କରିନାହାନ୍ତି, and
ମାନେ କଣଟା ସର୍କମଷ୍ଟାନ୍ସ କଣ ଆସିଲା କହୁନାହାନ୍ତି ଆପଣ, କଣ ଇନକ୍ରିମିନେଟିଂ ସର୍କମଷ୍ଟାନ୍ସ କଣ ଆସିଲା? ସେଇ ଏକ୍ସେପ୍ଟ ସେଇ ଯୋଉଟା କହୁଛନ୍ତି ଆପଣ, ମାନେ ସି ରିପୋର୍ଟର ଯୋଉ 3ଟା ଯୋଉଟା ଇଏ ରଖିଥିଲା ତା ଦେହରେ ଯୋଉ ବ୍ଲଡ ଟା ଲାଗିଥିଲା ଏତିକି ସେ ନାହିଁ କରିଛି। It further appears from this question number 7 it further appears from the C report exhibit 11 that on chemical test human blood was detected in the seized blood stain,
half
uh,
half shirt and lungi,
half
AB
pant,
group.
half shirt and lungi, a B group of human blood in the underwear, banyan, sari, saya, blouse। ଏତିକି ତ ହବ, ସେ ନାହିଁ କରୁଛି।
As far as the seized properties are concerned, so in that case, if you try to connect that to be one of the circumstance of the crime, then it must be very cogent. Where has the after the seizure, whether it was kept under sealed cover, and the item which was sealed was sent for chemical examination, it is both जरूरी ना।
କିଛି
That
କିଛି ନାହିଁ।
ଚୁପଚାପ
has not been brought in the cross examination.
Court, the cross-examination comes later.
ସିଏ କଣ କ୍ରସ ଏକ୍ସାମିନେସନ ଆଣିଲେ ଆପଣ ସିଲ୍ କରିଥିଲେ କି ନାହିଁ? କି ଆପଣ ତ ଚିଫ୍ ରେ ହିଁ କହୁନାହାନ୍ତି ନା। ଆପଣ ଯେତେବେଳେ ଗୋଟେ ଜିନିଷଟାକୁ ଜବତ କଲେ 27/9 ଏଇ ଯୋଉ ଲୁଗା ଫୁଗା ଓଦା ଲୁଗା ଗୁଡାକ
They can add it.
27/9 ଆପଣ ଜବତ କଲେ, ତାପରେ କହୁଛନ୍ତି ମୁଁ ପଠେଇଦେଲି ତାକୁ କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ। କେମିକାଲ
ମାସେ।
ଏକ୍ସାମିନେସନ ହେଇଛି ମାସେ ପରେ, ମାନେ ଯାଇଛି କୋର୍ଟରେ ପହଞ୍ଚି। କୋର୍ଟର ଯୋଉ ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ ଦେଖୁନାହାନ୍ତି, ଫରୱାର୍ଡିଂ ରିପୋର୍ଟ ଡଜ ନଟ୍ ଇଣ୍ଡିକେଟ୍, come to page number 50, that is the forwarding report. You see none of the articles was produced in sealed condition। କୌଣସି ଆର୍ଟିକଲ ଲେଖା ହେଇଥାନ୍ତା ନା ପେପରରେ ଇଏ ଥିଲା, ସିଲ୍ଡରେ ଥିଲା, କିଛି ନାହିଁ ଟୋଟାଲ। आईओ भी कहूनी जे आमे सील आउ जेरा रे केमती ये पचेर
जेरा काहे आनिबे
काहे आनिबे कोन दरकार
से रखिथान्ते ताको कहिथान्ते से निजे
हम्म
आमे आनिलु ताको सील कला परे ताको सील करा हला in presence of witnesses we put an identification mark with a paper slip with signature of both the parties जोटा कि खोलला बेलको से सिग्नेचर मिलला
आपण यार जो ये तो आईओ तो कहनी आपण जो गोटे साक्षी करथिले ए जो सीजर लिस्ट रो दीटा साक्षी रो बोधे गोटे साक्षी ना दीटा गई
No.
हां
7 and 9.
7 and 9 से मान किछि कहउछन सील कंडीशन विषय
No.
ସେମାନେ ଚୁପଚାପ ରହିଲେ ସାତ ଖାଲି ଜବତ କରିବା କଥା କହିଦେଲା in my presence so and so and office gave information to conceal this so and so
That was found in a decree
ହଁ ଡେକ୍ଚିରେ ପାଣି ଥିଲା ତ ଲେଖା
seized under
ଘୋଡେଇ
exhibit
ରଖା।
ଏତିକି signature he also gave recovery of check lungi how was it kept both are silent सात भी कौन है कि नौ भी कौन
ନା,
कि आयो भी कौन है
ନା। What is the magistrate order sheet ଟା ଟିକେ ଦେଲେ dated 27/9/27 27 ନର order sheet ଟା ନାଇଁ ସେଟା ହଉଛି additional session ଇଏର ଆମର magistrate ର
ये बेल ଅଛି ବେଲ ଅଛି
ये जो 27/9/1997 ର magistrate order sheet SDGM करम the record is put up today as the IO has made a prayer dated 26/9/17 to send the seized items to SFSL Rasulgarh Bhubaneswar for chemical examination. IO has submitted the seizure list dated 2/9/97 in respect of the articles mentioned therein. Prayer for the IO is allowed. Send the exhibits of the IO to the chemical examination to SFSL Rasulgarh. देखिले पेज नंबर सेटा होची 193 जो 251 रो 193 पेज टा पड़े आछन से देखंतु ऑर्डर शीट जो रेलेवेंट जो न प्रोड्यूस हला टोटल किसी नाही जे सील्ड कंडीशन में प्रोड्यूस हला ताकू की वेरीफाई करले गुडा सील्ड कंडीशन में थिला बोली 193 को पड़े आछन ए पटे बाहर कर दियो 193 पेज टोटल पेज होची 251 तारो 193 पेज रे मैजिस्ट्रेट ऑर्डर शीट
put up today. On the IO has made a prayer dated 26/9/97
to send the seized items
seized item to the SFL Rasulgarh
Bhubaneswar
for chemical examination.
IO has also submitted
Submitted a
seizure list dated 2/9/97 10 a.m.
10 a.m.
in respect of the articles mentioned therein. है ना? Prayer of the IO is allowed and the exhibits through IO for
For
chemical
chemical
examination
examination
to
to the
SFSL total silent. तवन आपण फॉरवर्डिंग रिपोर्ट रे नाही एठी भी नाही एबो जो सील्ड कंडीशन विषय किछि नाही जनो केमती आपण सेफ कस्टडी न हले जहाँ को आपण एते इम्पोर्टेंस दउचंती जो जହାର रक्त पाई से ता जदि सेफ कस्टडी रे न रहिला ताकू केमती रिलाय करी कि गोटे 302 केस रे आउ जदि किछि मटेरियल नहीं केमती ताकू ये करिवो एग्जामिनेशन रिपोर्ट दैट कम द
एग्जामिनेशन रिपोर्ट
सेटा पार्सल
केमिकल एग्जामिनेशन रिपोर्ट
कोंडा
कोड
पार्सल एग्जामिनेशन रिपोर्ट
ना ना एग्जामिनेशन रिपोर्ट पार्सल आसला आपण पठेले कि
सेटा तो मुख्य कथा और ताकू सेटा पुनी रूटेड थ्रू कि आईओ ही कि जाईछि बुझिला ना एग्जिबिट्स कोर्ट जरिया रे जाई माने कोर्ट रे प्रोड्यूस हला कोर्ट हैंड ओवर कर दला आईओ को से तार नै कि नि एसएफएसएल ले प्रोड्यूस कला एसएफएसएल गोटे रिसीप्ट मेमो थी बोले ये हला 27 तारिख से तक नै कि पहुंच हिची देखो ना दी प्लीज कम टू पेज नंबर 52 your memo number so and so advising one parcel was received in this office on 4/10/97 ये देखो नहीं कौन कला 27/9/97 रे तते मजिस्ट्रेट हैंड ओवर कर देले तू 4/10/97 पर्यंत कौन तक करथु कोर्ट रखिथुल एक तो थाना रे कोर्ट रखथुल एविडेंस नाही पुणी तार नहीं गला पर मजिस्ट्रेट को पुणी 4/10 पर्यंत रखिले निजे पर तापर आनिकिन प्रोड्यूस कले ठीक कौन कहबे appellant the appellant Kishanlal Sahu faced trial in the court of learning additional session judge Rairangpur in sessions trial case number 8/53 of 1998 for offense punishable under section 302 of Indian Penal Code. On the accusation that on the intervening night of 1997 30 तारीख रात्रि घटना 30/31 August 1997 night at Bahalda he committed murder of Lakhanlal Sahu. अच्छा नहीं वाइफ ऑफ वाइफ नाटा कौन से डिसीज्ड नाटा कौन PW3 टा PW3 नहीं
अरे पीडब्ल्यूडी इन्फॉर्मेट
देइछि
दास स्त्री नाटा कौन डिसीज्ड नाटा कौन
निर्मल
हाँ लगन निर्मल कमा the wife of Lakhanlal Sahu that was PW3. The Lenin trial solely by judgment and order dated 25/8/1998 found the appellant guilty of the offense charge and sentenced him to undergo RI for life. So, the prosecution case in short as per the first information report lodged by PW3 Lakhanlal Sahu before Prashant Kumar Bishay, OIC of Bahalda Police Station on 31/8/1997, in short, is that in the night of 30th of August 1997, he, along with his wife, bracketly deceased, and children, after taking their dinner, went to sleep. At about 1:30 in the night, PW3 got up from his sleep and found that the deceased was not there on the bed, and he sent his elder daughter, Madhumita Sahoo, PW4, to see whether the deceased had been to attend the call of nature, and PW4 returned and told PW3 that the deceased had been to attend the call of nature. After some time, when the deceased did not return back, PW3 went and found that the deceased was washing his hand and feet after attending the call of nature, and told that she had been to ease herself, and after taking bath, she would come to the house and ask PW3 to go and sleep. So PW3 returned back and went to sleep, and at about 3:30, at about 3:30 in the night, he heard the water coming from the tap, and came out and found the deceased was sleeping by the side of Tulasi Chowra, and
Did not respond to his call.
did not respond to his call, and when he came closer, he found that there was he was lying in a pool of blood, and
She was lying dead in a pool.
so he was lying dead in a pool of blood, and
Yes.
the daughter, the PW4, came there, and she also tried to wake up her mother, but she did not respond. PW3 went and called
his brother.
his elder brother, Madanlal Sahu, bracketed PW6, and also the other co-villagers. It is further stated in the first information report that the appellant was his elder brother, and there was dispute between him and the elder brother in connection with land dispute. And cases are also pending in the court of law. And the appellant had also broken the finger of the PW3 in 1997 over some dispute. And thereafter, the matter was amicably settled between the parties. Thereafter, also in connection with the water connection as well as toilet, there was a dispute between the two brothers. Stop. And the appellant was threatening to commit the murder of someone in the family over the partition of the properties. Stop. The Peter, believing that the appellant and his wife are involved in the commission of murder of the deceased by assaulting her in any sharp cutting weapon, the first information report was lost. Stop. PW10, after registering the first information report, on the basis of such written report, PW10 registered Bahalda PS case number 45 dated 31/8/1997 under section 302 of the Indian Penal Code against unknown person. Stop. After registration of the case, PW10 himself took up the investigation, visited the spot, prepared the spot map, Exhibit 9, examined the informant and the witnesses, held inquest over the dead body, prepared inquest report Exhibit 5, sent the dead body for post-mortem examination, seized Boston R sample R and Boston blue half pant, white half pant, school uniform of the son of the deceased, white seizure list Exhibit 8, arrested the appellant. Stop. Appellant, while in police custody, gave a statement and led the police party and others and gave recovery of iron putty and chopper from the top of the almirah inside his kitchen, and which was seized as per seizure list Exhibit 6. He also, while in police custody, gave information regarding concealment of his lungi, banyan, and chaddi inside a dekichi submerged in water in inverted position, and took the police party to his bathroom and gave recovery of the same, which was seized as per the seizure list Exhibit 7. The appellant was sent for medical examination, and his nail clippings, etc., were produced by the constable, which were seized as per seizure list Exhibit 10. And the wearing apparels of the deceased were produced by the constable after postmortem examination, which were seized under seizure list exhibit 3. And the IO produced MO1, the items one so before the doctor, and made a query regarding possibility of the injury sustained by the deceased with such weapon, and received the query report. He also sent the seized articles for chemical examination through court. And on completion of investigation, he submitted charge sheet against the appellant under section 302 of the Indian Penal Code. Stop. After commitment of the case to the Court of Session, the charge was framed against the appellant, and the appellant pleaded not guilty and claimed to be tried. And accordingly, the session's trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 10 witnesses. They were key upon. The prosecution also exhibited 11 documents. They can prove 4 material objects. Stop. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that the deceased has died a homicidal death, and considering that in the night of 30/8/1997, in the common courtyard of the appellant and the PW3, and little away from Tulasi Chaura, towards the house of the appellant, the dead body of the deceased was lying. The appellant led to recovery of MO1, pottery, and MO2, 3, and 4, the wearing apparels, bloodstain wearing apparels, which the appellant had kept, and the opinion of the doctor, bracket PW1, regarding possibility of the injury sustained by the deceased by MO1, chemical examination report that the blood found on the recovered banyan and undergarment of the appellant tallied with the sample blood of the deceased, and blood found in the seized wearing apparels of the deceased, and that there was dispute over partition of property between the parties, and there was a quarrel between between PW3 and the appellant and his wife, PW3 on one side and appellant and his wife on the other side, and that the appellant expressed that murder of any member of the family would only be the solution to pave way for partition, came to hold that there is irresistible conclusion that the appellant and none else the author of the crime. The Mr. Dhal Samant, Land Counsel, appearing for the appellant, that there is no direct evidence in the case, and the case is based on circumstantial evidence. And the main circumstances are the recovery of the weapon of offense as well as as well as the wearing apparels of the appellant at his instance on the basis of his statement given before the IO. However, from the C report, it would appear that no bloodstain was found in the iron chopper, and so far as the wearing apparels of the appellant is concerned, there is no cogent evidence that it was kept in safe custody before it was sent for C examination, and therefore the findings of the C report should not have been given any importance at all by the London trial court. It is further argued that if such evidence is taken out of consideration, the other materials are insufficient to form a complete chain to come to a irresistible conclusion that it is the appellant and appellant only who is the author of the crime. And in view of the previous dispute, the false implication of the appellant in the murder cannot be ruled out, and therefore it is a fit case for giving benefit of doubt to the appellant. Mr. Jateshwar Naik, Land Additional Government Advocate, on the other hand, supported the prosecution case and submitted that in the compound in which the dead body of the deceased was found, the dead body was found very close to the house of the appellant, and no third person except the family of the appellant as well as the deceased were residing therein, and there is a compound wall and the door was closed, and the London trial court has rightly taken into account the previous dispute between the parties, the threatening given by the appellant, apart from the leading to discovery of the material objects, particularly the banyan and underwear, from which human blood of AB group was found as per the C report, which tallied with the blood group of the deceased, and the appellant has not offered any explanation in his accused statement, and therefore the conviction of the appellant should be upheld. Stop. Adverting to the contention raised by the London Council for the respective parties, since the case is based on circumstantial evidence, we have to keep in mind the off-quoted decision of the Honorable Supreme Court in so-and-so case, the 84th Supreme Court, where the principle laid down that in order to convict an accused on the basis of the circumstantial evidence, the court has to come to the conclusion that so-and-so, 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 Panchashil.
Sarath Bridichan, like
Sarath Bridichan Sarda was the state of Maharashtra, 84 Supreme Court. And in the case in hand, the homicidal death of the deceased is not disputed in as much as the doctor bracket PW1 who has conducted postmortem examination on 31/8/1997 at SD Hospital, Rairangpur, has stated that he has noticed the following injury scored there, and he further opined that death was due to hemorrhage and shock due to the injury to the skull bone, and time since death is 12 to 40 hours, 24 hours of the PM examination, and he has proved the PM examination report as Exhibit 1. He has also examined the chopper, which iron chopper, which was seized at the instance of the appellant and produced by the IO, and gave his opinion that the injuries on the deceased are possible by such weapon, and the query report has been marked as Exhibit 2. Stop. Since the homicidal death is not disputed, we have to see that what are the further materials available on record, circumstantial evidence available on record, and whether those circumstances form a complete chain or not. The main circumstances, as rightly pointed out by the learned counsel for the appellant, are the recovery of the weapon of offense MO1, cautery, and the wearing apparels of the appellant, which was seized at his instance, and that is the underwear and banyan from which human blood of group AB was found. The IO has stated in his evidence that after he arrested the appellant, while in police custody, the appellant gave information regarding concealment of the iron cautery in the top of the almirah inside the kitchen, and then gave recovery of that cautery, and he also proved the seizure list, Exhibit 6. MO1 is the said cautery. The witnesses to this seizure of cautery are PW 7 and 9. PW 9, and both of them have also stated about the same. Similarly, so far as the wearing apparels of the appellant are concerned, PW 10, the IU has stated that while in police custody, the appellant gave information regarding concealment of his lungi, banyan, and shoddy inside a dekiji submerged in water in inverted position inside his bathroom, and gave recovery of the same, and the banyan has been marked as MO2. Lungi has been marked as MO2, banyan as MO3, and underwear as MO4. And the relevant seizure list is Exhibit 7. The PW7 and PW9 have also supported the seizure of the wearing apparels. However, neither in the evidence of the IO nor in the evidence of the two seizure witnesses, there is anything that after the seizure of the cautery, MO1, or the wearing apparels, that is MO2, MO3, and MO4, those were kept in seal custody, under seal. Stop. The IO evidence is completely silent as to what he did with the seized articles after its seizure, before he produced the same in court for sending the same to the for chemical examination. The Malkhana register has not been produced in this case, And the articles were seized on 31/8/1997, and it was forwarded to court on 27/9/1997. In the forwarding report, there is nothing that any of the articles were in sealed condition. The order sheet dated 27/9/1997 of the London SDGM, Rairangpur reads as follows. For the order sheet dated 29/7 inverted comma, 27/9 inverted comma. The record is put up today as the IO has made a prayer dated 26/9/97 to send the seized items to SFSL Rasulgarh, Bhubaneswar for chemical examination. Stop. IO has also submitted the seizure list dated 2/9/1997 bracket 10 AM in respect of the articles mentioned therein. Stop. Prayer of the IO is allowed. Send the exhibits bracket T1 through for IO for chemical examination to SFSL Rasulgarh, Bhubaneswar. Stop. The order sheet is also complete silent regarding the manner in which the articles were produced, or that the court put any seal on the seized items. The report, the examination report of the state FSL indicates that the articles were received in a packet on 4/10/1997. If the articles were handed over to the IO by the London SDGM on 27/9/1997, then there is no explanation as to how the delay was caused in producing those articles before the SFSL on 4/10/1997, and in what condition those articles were kept till those were produced. Therefore, when the safe custody of the seized article is a doubtful feature, it is very difficult to give importance to the finding of the C report regarding the matching of blood group in the underwear and banyan of the accused with that of the deceased. Stop. If this vital evidence is taken out of consideration, then the other evidence, like the previous dispute and the threatening given by the appellant previously, in our considered opinion, cannot form a chain so complete so as to come to an irresistible conclusion that it was the appellant and appellant alone who is the author of the crime. Therefore, we are of the view that the impugned judgment and order of conviction is based on surmise and cannot be sustained in the eye of law, and therefore same is hereby set aside. The appellant is acquitted of the charge under section 302 IPC. Criminal appeal is allowed. He is on bail.
Bail.
The bail bond is cancelled. Put a note of appreciation on Mr. Bhabsaman.